Acts and views, the unamended and the amended army instructions. According to the appellant, officers similarly situated with the appellant were also not given an opportunity to appear for the clinical test and interview in view of the amendment. Quickly moved applications to the principal bench. We have dealt with the judgment in that batch. It is a well-settled principle of law that where a citizen, aggrieved by an action of the government department, has approached the court and obtained a declaration of law in his/her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. We have cited Amritlal Berry and K. Shepherd. No doubt, in exceptional cases where the court has expressly prohibited the extension of the benefit to those who have not approached the court till then, or in cases where a grievance in personam is redressed, the matter may acquire a different dimension and the department may be justified in denying the relief to an individual who claims the extension of the benefit of the said judgment. That is not the situation here. And then the respondent authorities on their own should have extended the benefit of the judgment of AFT principal bench in OA 111 of 2013 and batch to the appellant. To illustrate, take the case of the valiant Indian soldiers bravely guarding the frontiers at Siachen or in other difficult terrain. Thoughts on conditions of service and job perquisites will be last in their mind. Will it be fair to tell them that they will not be given relief even if they are similarly situated, since the judgment they seek to rely on was passed in the case of certain applicants alone who moved the court? We think that that would be a very unfair scenario. Accepting the stand of the respondents in this case would result in this court putting its imprimatur on an unreasonable stand adopted by the authorities. We have distinguished Anant Kulkarni's case. We have referred to the two orders mentioned in the counter. We say they have no application. One of them supports the appellant. There is no delay in approaching the tribunal. We also find that the appellant, a woman officer, has continuously worked since 2007. And even as late as on 31/10/17, she was granted an extension of another 4 years of service. And she continues to be in service thereafter also on account of the status quo order of this court on 8/3/2022. Not only this, the appellant was awarded commendation card by the Chief of Army Staff on 14/1/2019. It is also undisputed that the appellant has had a distinguished service and is now posted as Lieutenant Colonel in the Army Dental Corps at Agra. We hold that the appellant was wrongly excluded from consideration when other similarly situated officers were considered and granted permanent commission. Today, 11 years have elapsed. It will not be fair to subject her to the rigors of the 2013 parameters, as she is now nearly 45 years of age. There has been no fault on the part of the appellant. On the peculiar facts of this case, and since nothing adverse has been placed on record with regard to the performance of the appellant in exercise of powers under Article 142 of the Constitution, we direct that the appellant ought to be given permanent commission. We direct that the appellant's case be taken up for grant of permanent commission and she be extended the benefit of permanent commission with effect from the same date. The similarly situated persons who obtain the benefit pursuant to the judgment dated 22/1/2014 and OA 111 of 2013 of the principal bench of the AFT. All consequential benefits like seniority, promotion, and monetary benefits, including arrears, shall be extended to the appellant. The above direction shall be implemented within a period of 4 weeks from today. The appeal is allowed. The order of the AFT of regional bench so and so is set aside.
Very grateful, Your Lordships. My client is most grateful to Your Lordships for this case.
We only done our duty.
Very grateful, Your Lordships. One.
Afterwards, still be preferred against the criminal appeal. Any date may be given.
Vacation.
Any date.
In and after vacation, now there are hardly any time left before the vacation. Immediately after vacation.
Directed to the matter to be listed after 2 weeks by 11th of November 24. Lordship, it was shown in the last week's list, but it has not been, there is no date showing.
What is the matter about?
It's an anticipatory bail cancellation filed by the complainant, who is the father of the deceased widow, deceased woman, who was, our submission is that she has died due to the suicide which is committed due to GAVAI allegation. Then
The next speak, please.
the respondents have been served. Grateful.
Lordship, the matter has not been listed ever since after the notice has been issued in 2016. The last date it was listed in court number 3 on 5th of November, but then the matter was not dismissed.
What is it about?
It's not,
What is the matter about?
it's an insurance claim.
You are for the claimant.
It's not true.
Okay. After vacation.
Should anything before we-
Not before vacation.
It's before.
Please, Your Lordships. Lordship, this is a criminal appeal. I have been convicted under POCSO. I was acquitted by the trial court. The High Court reversed the conviction and sentenced me to an imprisonment of 10 years. Lordship is 86 years of age and he's already undergone 4 out of 10 years. Lordships, any date that suits Your Lordship's calendar, maybe after vacations.
For suspension of sentence or
For
for?
suspension of sentence, Your Lordships. Because he's 86 now. He's a priest accused of POCSO offense.
That's from Kerala.
No, Your Lordship, Haryana.
Next week.
I did next.
Item one,
I'm sorry, Your Lordship. Can Your Lordships allow me to mention, Willis?
Yes, Dr. Singhvi.
Willis, Your Lordships had indicated Manish Sisodia's small application for tomorrow. It's just not come in the list. Your Lordship may add it to the list. It's a very short application. Lordship put it for tomorrow by an order. That one which requires you to report to Willis.
As a modification, yes.
Yes, that 4 authorities in the same day every week, Willis.
Okay. Day after tomorrow.
Day after. I'm obliged. Deeply obliged.
Okay.
Lord, may I mention a matter?
Yes.
Lord, may I mention a matter? Lord, it's the after notice matter. It was supposed to be listed tomorrow, but it's not in the list, Lord. I'm in the jail since more than 4 years, 9 months. It was listed on 21/11.
The conviction is how many days?
Oh, under trial.
Under trial.
Under trial. 4 years, 9 months already completed.
302.
Yes.
Next Monday?
Friday.
Not Friday. Kal parso.
Yes.
Milord, may I mention, Milord, that? Milord, I had mentioned the last week also, Milord, the correction in the order of 25th of November. I am for the wife, Milord, acid attack victim, Milord, the maintenance matter, Milord. Milord had asked me to inform the other side so that, when I have filed the short application, Milord, that may be listed, Milord. I have served the other side.
Okay.
Any date on it?
That year correction, year.
Here
Maintenance.
and my submission. Great.
Please, I'm appealing for the Lordship. Big survival, but I'm appealing the state. Because the charge sheet has been filed, my lord, on 30th of December 2024. Sorry. The charge sheet has been filed on 30th of April 2024. And matters actually posted on the 30th December, my lord, December 2024. To serve, it has become CC number, my lord, and the case is pending before the special judge, Metropolitan Magistrate.
they have entered appearance, we have filed work.
And in fact, your lordships have actually protected.
So we'll confirm the interim order.
Yeah.
Confirm and you did lordship.
The charge sheet is already filed. In that way, we are inclined to allow the application. The order dated 21st of March 2023 is made absolute.
In the other matter, my lord, the order dated 29 May 2023, where your lordships have said not to arrest him. So that was.
That also being confirmed.
Allow the
Obliged, Lord.
I'm led by the learned ASG, Your Lordship.
Lordship.
Kind enough to pass it over.
Lordship, only because there was a wrong information which was held by me on the last occasion. In this matter, 2 of the accused are on bail and one that's on bail. The wrong information was received by me.
What wrong information was received?
On the last date, I was informed that by the local council that all 3 were on the other 3 accused. 2 are in jail, against which and other 3 are on bail. But out of the other 3 are not on bail, 2 are on bail, and 1 is absconding.
Millets, Mr. Thakur is on his legs in court 5. However, we have taken instructions. If Lordships can pass it over, I'll request the Honorary ASC to appear.
Pass it.
Last.
Well, I'm saying 3 weeks time to file counter affidavit in this matter.
But counter may be required to see whether there is any link with him. That Garima Sharma is who we have to, your link you have to trace.
Please, Minister.
Counter एक आपको
2 weeks. Thursday को लगा लेना. अभी इसके बाद कर. Application के पहले.
Some copies of bail order, Lordship, in additional documents that we issue.
Yes, who is yes, Mr. Singh.
Any cases of similar nature?
Maybe it's Lordships. In my lords, in all the orders, my lords may see that all the matters are being settled between the complainant and the petitioner, my lords. And my lords, the name of the petitioner is also in the FIR as well, my lords. And there are not only one complaint, there are more than 90-20 complaints in this matter, my lords. This is a matter of duping the money of the innocent, my lords, people who are trying to invest money in my lords' company. If my lords may see, there are more than in our counter affidavit, and plus in their additional affidavit, in every annexure, my lords may see that every matter is being settled, my lords, between the complainant and the party matter. They have what they did, my lords, they have given the money back.
Why don't you settle with the
Lordship, I have already paid the money. Lordship, in this present FIR, there is not my name, Lordship. Lordship, secondly, the investor agreement is taken place between main accused. He has already paid 5 lakh rupees, Lordship. Apart from it, there is no complaint against me regarding it.
First of all, there is a name of the petitioner in the present FIR. If my lords may come to
how many total number of persons you have?
Lordship, total 8 lakh amount.
No. How many people you have duped? You are facing so many.
There is a charge.
that is incomplete, my lords. The charge which has been mentioned in the additional document, my lords. They have placed FIR. My lord.
Order I in this case.
See the page number 9 of the rejoinder.
Yes.
Your main focus is Kerala. I think there are many gullible people.
Lordship, I am running a financial company. If somebody face any grievance, he filed FIR against me, and I have already settled the dispute, all the dispute. Even some of them matter FIR is final report, police file final report.
Pan India operation. No, I'm not undermining. Pan India is there. Punjab, Maharashtra, Telangana, Gujarat, Madhya Pradesh.
Yes, Lordship, all the matters, almost all the matters settled. Only in Punjab, Honorable High Court issued notice in the bail application and FIR question.
Gujarat bail is pending. Gujarat is Vadodara. Then there is.
It is a fresh FIR, Lordship, lost between.
Punjab bail pending.
Honorable High Court already issued notice in question of FIR even in this case.
Let's find out how many.
My lords, as per my lord direction, we even called to the different state and asked for their status of the FIR and what is being going on there, like how the matter is being compromised, my lord. But no, my lords, no assistance has been received from their side, my lords.
Any received any notice?
Because this is a matter related to my lords, states, my lords. So if we are trying to get it to connect, it's taking time, my lords. First of all, then secondly, my lords, on a prima facie, my lords, it's
Petitioner,
Keep it up to 4 weeks in the meantime.
Lordship petitioner is not running, he may be, you may impose any term upon him. Lordship.
Let us see your high credentials. Let us have some information about that. 4 weeks, yes.
4 weeks, sir. Great.
As it already had been filed, Lord,
Number 4 weeks.
Okay.
Item 6.
Yes, who is there? Password.
Item 7.
Well, I have been in jail for last more than 1 year, 1 year, 3 months. And there was no independent civil witness also here. And already there are 3 persons who are out on bail. They are the main people who have the dealership license of having this computer. I am a poor person, my lord. I've been caught and
18 on your motorcycle, 110 in your house, and you are saying you are poor. 110 bottles found in your house.
Mine was, my lord. That was Gopal Das's house.
No, from your own house.
Your own
My brother is absolutely right. 18 from the vehicle
Motorcycle.
and 110 codeine phosphate syrup from your house.
Involved in the same racket, involved in the illegal purpose. Is that at page 30, my lord? Yes, my lord. Well, another, the High Court has said that
Anyway, notice written 4 weeks. Wishing notices.
I'm so flesh.
Short password.
मोटरसाइकिल में घूमने जा रहे हैं सिस्टम लागू
Password. Item 8.
9.
May I please, Your Lordship? Lord, my bail has been rejected by the High Court. Lord, this is a case where the owner of the property, Sanjay Gupta, he has been granted anticipatory bail. There were 3 occupants in the building, my lord. They were carrying on their business. One Mr. Alok Rastogi, he admittedly, my lord, even according to the charge sheet, my lord, he was running a business of soap and he was storing phenyl, which is an inflammable item. He has not even been made an accused. The third gentleman, Udit Raj, he was running a business of repairing printing machines, etc. My lord,
you are manufacturing some plastic items.
My lord, I was manufacturing plastic items. That is the case against me. But my lord, the point is that the allegation is that there was an explosion. Now, the NGT also directed, my lord, a high-level committee, including the ADM and the police officers, my lord. They went to the premises. They found that, in fact, there was no electricity connection operating at the time of the incident. The electricity had been disconnected the previous evening because of some fault. This event occurred early in the morning, my lord, and the report before the NGT says, if I may show to your lordship, that there were some workers, they were cooking their food, etc. And at that time, the explosion took place.
The residential area, Mr. Sanghi.
Pardon,
It's a
my lord?
residential area. It's a residential area. This.
My lord, kindly see, this residential area misuse, that is a different thing, my lord. Here we are dealing with a criminal offense.
5 persons have died in the.
No,
Well,
when you say 304A and 304, the whole thing is whether it's 304A or 304 is what your argument also is.
Yes,
Makes
yes,
a world
sir.
of difference. This makes a world of difference.
No, kindly see, my lord, the immediate act which caused the death is the explosion. It is nobody's case that I caused the explosion knowingly. Intention, of course.
We are issuing notice.
Grateful.
Notice period of 4 weeks. Yes.
Grateful.
Well, I appear for the petitioner, Malits. I appear for the petitioner, Malits.
Coming up first time after notice, I need to put in my counter affidavit. I've been given 3 weeks.
Well, as your lordships have said, in liberty matters, this practice of coming and saying first time after counter and then taking counter, well, they could have done something. In some cases, they haven't filed wakalatnama. Time is taken, then again, well, kindly give the shortest time if possible, well, subject to my lord's convenience.
Friday or Monday.
When you come for de facto complaint, you will also ask for counter.
No, I don't. First of all, they could have filed a counter earlier, Malus. They could have filed it earlier. But even if they do, Malus, give it very short. They were served a while ago.
2 weeks so that they can file a counter. Friday, they can file 2 weeks.
It's from which place?
Enforcement.
Enforcement Directorate, Delhi.
Yes, sir.
Why should it take so much time?
Give me about a week's time.
It would.
Deeply obliged.
This is a case where there are total 5 accused persons, including the present petitioner. Now 4 have already been enlarged on bail. My name does not appear in the FIR also, I am not a beneficiary of the alleged forged power of attorney. I have been implicated only on the basis of statement made by one.
Yes, notice period over 4 weeks.
Some date may kindly be given.
We'll give the date, yes.
Yes, probably.
I'm appearing for the newly impeached respondent Ministry of Home Affairs. I'm waiting for some time to file wakalat and give my response.
SOP has to be first order of court.
I saw that on first.
On both the counts, lordships, about the impact on the BNSS as well as the health department lordships.
Learned ASD 6 time. Right. Well, counter content.
Appear on behalf of the but substantive cross objections filed by me are not considered at all. I is out of the Land Acquisition Act for fixation of compensation. This will not be impugned judgment, while dismissing the appeal filed by the MSRPC. Not a word about my cross objection. Page 23, only 2 paragraphs about their appeal. Page 23 para.
The reference code grants you 350 and 400.
Yes, sir. And I was claiming 500. And one substantial error committed is on solatium, no interest is mentioned. And will not file constitutional bench of your lordship will not have held. That will not interest component has to be awarded on both. And you all merits not a word about my cross objections. Page 23, para 20 and 21. These are the only reasons.
What is the exemplars that you are relying on?
Please have a look at for that. The sale deeds, page 110, which are considered and will
Not considered actually. Even para 38 of the reference order.
Yes.
Just narrates it.
That's all.
You are saying that 1990 is 350 and 92 is 392.
And something we are produced of 93. Lord, your Lordship, also grant me Dasti and returnable date so that Lord, I will. If you notice, remember 4 weeks. Please, Dasti be omitted.
Your Worship, I request for record accommodation in the matter as your is getting married. As your is getting married, is at his hometown.
Okay,
Request for record accommodation.
I'm appearing on KVM if my lord could have it after the.
Where are they gone for marriage?
Sikkim. Where has he gone for marriage was the question.
Is at his home village in Uttar Pradesh.
Okay, convey our congratulations. And best wishes.
According to judgment, Thakur, citizen got 2 in paper. Marriage qualified as grave personal development.
Grave personal.
Ensuring personal.
Saurav, you could get into trouble. It's all videographed now.
It's after vacation.
This is a case where there's prima facie case of contempt found by the court. And then after that, there is a Lord who's a tree officer, but he is cut on his watch after he has been specifically directed by the court to pass protective orders, take protective steps. After that, my lord, a tree is cut. And then after that, my lord, prima facie case is found. Subsequently, he disappears from the record. Well, this is against that omission to do anything about that content. If I may show, the prima facie case, my lord, 137, notice is issued to both respondents. There's a private respondent who
No,
comes.
but against the other respondent, where is the positive direction?
Your Lordship, it is precisely that. The difficulty is the tree officer. There's a notice issued to him carried out. After that, my lord, there is no finding, convicting, or acquitting him. It is acquittal essentially by omission. I am only saying if today he had been acquitted after some reasoning, my lord, I wouldn't be standing here. But
No,
it
you
is
show
acquittal
against the party who's not been dealt with. What was the obligation cast on him under the underlying order of which you are complaining of contempt?
I'm very grateful, my lord, because that obligation is at page 74. It says 74, my lord, paragraph 5. Respondent shall ensure that the tree is at the two locations. At this point, respondent is the tree officer, with regard to whom I'm complaining. At the two locations which form the subject matter of the present writ petition are not felled or harmed in any manner, insofar as they are concerned, shall apply. Your Lordship, under the Any Tree Protection Act, there's a power to issue a protective order. In fact, what is particularly black in this case, my lord, is at page 135, he issues that protective order after the trees have been cut, after I go and complain, after I try to file an FIR. So he knows of this duty. This duty is something well within his power. He doesn't carry it out. It is straight away contempt. I am saying that the Learned High Court ought to have considered this. Instead, on a mere allegation that basically that there was a forged permission or something, that man is let go of. And subsequently, my lord, the same tree officer has been involved in multiple contempts because he has been.
He has not been let go of. He has been.
Contempt, prima facie finding on 2 dates by 2 different judges, my lord.
Order, he issues the consequential order on 14/11 only.
Yes, after the things are cut in October. And after I have already gone and filed in contempt finds and prima facie something on the 3rd of 11/22, 3rd of November. Subsequently, he waits that protective order. If he had done it at the right time, those trees would have been standing. Your Lordship, I'm saying this is actually some kind of cunning design. There's omission on one hand, and then there's positive commission on the other. Subsequently, my lord, in another case, there's a contempt where 132 trees have been cut down pursuant to permissions by the same officer in contempt of, again, directions of the High Court.
Issue notice restricted to respond number 1. Other one is already held. He is suffering from cancer.
The other one, my lord, whatever judged.
May I please, your lordship? May I please, your lordships? Lords, in this contempt petition has been filed against in which coercive directions have been passed against me for non-compliance of the directions given by the learned writ court in the at para 26 or at page 26 of this SLP. My lords, may have it para 26 for a moment.
Oh, what was the order of the High Court?
My lords, it was to regularize him after completion of 7 years of service and grant him consequential benefits. That, my lords, we have done.
No. When does the period of 7 years expire?
July 2001. We have regularized him from July 2001. My lords, we have.
And you grant him regulation from what date?
July 2001, my lords.
No.
The order was passed on 25th of January 2024. My lords, may have page number 22, page number 29.
Page number 29.
Page number 29, my lords, last paragraph. Now, therefore, in compliance.
Yes.
This is the operative portion of the compliance order of the regularization order, my lords.
And with monetary benefits prospectively.
My lords, fixation of pay. My lords, fixation of pay has been granted from 2001 itself.
No, you just see your own synopsis page C cross 4 of what you have not done. And then see the operative order. Not directed the petitioner to pay any monetary amount from the date of completion of 7 years service. Clear direction that you should give all consequential benefit. Clear.
My lords, monetary benefit, by monetary benefits, I mean that the salary difference from that date. My lords, notional fixation of salary fixation has been given from 2001 itself. That's why he. Pardon, my lords, I'm sorry.
Notional may result in fitment and fixation. What happens to actual cash in hand?
It is made clear that the petitioner shall be entitled to be regularized with effect from date he completes 7 years of service with all consequential benefits.
Please, my lords, in compliance of that, we have regularized him from 2001, fixed his seniority, fixed his pay, and that is why today he is getting 53,000 per month. Otherwise, if fixation of pay would not have been done from 2001 itself, he would be drawing 26,579 only. Today he is drawing.
Have you challenged the order of the High Court?
Please, my lord, it has attained finality, my lord. This LP has been dismissed against that writ court judgment.
Thank you. Dismissed.
I'm grateful. My lords, if my lords may say that I may be granted 4 weeks time to make the compliance of the judgment.
So we are not inclined to interfere with the impugned order. The 4 weeks time is granted for complying with the directions of the High Court.
Deeply grateful.
My lords, I must at the outset state, and I filed that order, that my lords have dismissed the contempt which was filed by these people. I'm on a very limited aspect. My lords have given a declaration that everyone who had done that exam, because the exam was conducted in 2003, they are qualified and eligible. Now, they filed a compliance report saying that 23 of us who come in that particular category and give a list. My lords, after my lord's order, we made a representation to them because it was their own statement in that compliance order made before my lords that everyone who has cleared the exam in 2002 has been given appointment, but we had not been given, and we are told there are 2,000 vacancies still. So my lords, all that we are saying is that my lords may just ask them at least my representation be considered, because there is a statement, a solemn statement made before my lords. If my lords will see page 25 of the compliance. Page 25, my lords. My lords, the order of which the compliance is also 5th December. My lords will find operative portion at 21, but at page 25 bottom, serial number 8, my lords have that. That is 290 candidates. Those candidates who cleared diploma by passing back paper in April 2003 are 23 in number and are categorized at H. Then my lords over the page. Now this my lords upheld.
Page 25 is
My lords, page 25 is their letter or affidavit of compliance starts at 22. Because it will be the application, miscellaneous. I think my lords may have a wrong one. So my lords, directions are at page 21, and the part of that compliance affidavit I wish to press is page number 25, my lords. My lords have bottom of page 25, they said 23 number, and if my lords will see over the page. Now, we then become qualified and eligible as per this. It is relevant to point out that the department in compliance of order dated 3rd August 2010 has given appointment to pharmacists up to the year 2002. So, my lords, I stand eligible and qualified because of that. Now, my lords dismiss my contempt. That's all right. I'm not pressing on that. But my lords, I made a representation to them. They have 2,000 vacancies. I only say that a small notice from my lords will at least push my representation to be decided whichever.
Why should we impose it? In the present, however, we direct the authorities to consider the representation made by the petitioner in accordance with law as expeditiously as possible, and in any case within a period of 6 weeks longer.
I'm so grateful, my lords. Much obliged.
My lord, this is a matter wherein the award was enhanced by the.
Your file shows. We are glad you are willing to argue.
My lord, only one factor here, the consequence will be borne not by the state itself, it will be ultimately the public purse. And my lord, PWD Dholpur's property.
How much cost we should impose?
My lord, kindly, see, my lord.
Thank you.
My lord, just one submission. We made a submission before the trial court that.
Your appeal once is dismissed in default also.
No, my lord, finance department sanctioned by.
That shows how careful you are.
Second time, unwilling to argue. That's why we said we are grateful you are willing to argue.
Last opportunity, my lord, because no, kindly consider this fact that finance department's sanction might come, so we may be able to pay.
Dismiss with costs.
No, my lord, I'll reconsider the cost amount, my lord. The appeal is listed for 3rd of January, my lord. Since that date, at least some relief.
No, sorry, not appeal. Grass matter.
My lords.
Yes, today you are online.
Yes, my lords.
We have to advise you the other day also that you should list only one matter a day.
My lords,
how many more are remaining?
My lords, there are few matters. That's all. Out of 71 matters, there are few matters.
Clear all your backlog prior to New Year. List other matters before vacation.
Yes, my lords, sure, my lords. My lords, the first case is concerned, we have deposited the amount, we have, the land is vested with the TNHP. My lords can have it this matter next week. I can give you a chart, the matters under which the land has been vested with the TNHB and the amount has been deposited.
We can't discriminate between different matters.
No conflicting decrees.
Well, as when the twin condition as per Indore municipality, if it is complied with, we can go ahead with the,
But these are
at least to
finally
some
violated.
extent. Yes, my lords.
Sorry, madam, thank you.
Grateful, lords.
Under the scheme of 1993, we were given the benefit by an order of 1996, 27/5/96, which the Honorable High Court Division Bench grants me the benefit on 15/6/17. If I lodges have page 75. In item number 63 minutes. I'm sorry. First, your lordship will take page 62 minutes. The original order which grants me the benefit on 27/5/1996 minutes. Page 62, your lordship have E.
63.
63, I'm sorry.
Page?
Page 62 minutes. The original order of 27/5/96, which grants me the benefit of the scheme, under which I was entitled to GPF. Now, the High Court on the 15th June 2017 upholds the order of 96 and says I am entitled to the benefit. Your lordship dismissed the SLP on 23rd March 2023. Thereafter, the contempts were revived before the High Court. Now, in the High Court, what happens is initially they issue an order granting me the benefit as I was entitled to under the scheme of 1993. And thereafter, by corrigendum, withdraws it, which the High Court says that this is substantial compliance. With my respect, it says that you go back, you take your remedies before the appropriate court.
Only GPF and EPF is
Yeah,
in place.
that's the case. I am entitled to GPF, madam. Your lordship dismissed the SLP. First,
Notice within polls.
I'm grateful. There's a permission also to file SLP by the widow of one of the business. Let me know.
Affair of 2010, my lord. The respondent police filed report before the stated before the High Court, my lord, stating that action has been dropped. Even thereafter, now pursuant to the
23 years old.
titles are not antiquities, my lord.
By the archaeology department that there are.
Even otherwise, antiquities that I am entitled to file a license and give the my lord.
Issue notice. Written police.
Please, and there is a maintenance case provided without considering if she is well settled prior to this date and filing of this famous petition by me. She was employed.
He was 20,000.
35,000 is there.
And 15 in domestic, 50 are. 1/4 you can give to her. You are getting 2,20,000 in Dubai.
And in the previous history, she was well employed. She was
Now she is not employed.
And since well filed the cases, she filed multiple cases against me. And not working. Now she is doing the law. Finally.
Very good. See, we are paying 13%.
Maybe opposing you soon.
Before going into the merits of the case, I make one proposal. She agreed when both were summoned to the police station. She agreed if you pay 1 crore, then everything will be settled. So I am prepared to pay the alimony to settle off this all the cases.
1 crore. You are willing to pay 1 crore?
Whatever your lordship fix it, first let her go from her position what she stands before your lordship. I agree.
What was she doing earlier? Prior to marriage, what was she doing? See.
She is a graduate engineering. She was working even in Dubai also. Sometimes she worked.
Issue notice. Since this dispute is basically a matrimonial dispute, you should notice to explore the possibilities of amicable settlement. To deposit litigation expenses.
Litigation expenses.
The legal aid should not be legal aid should be. So the petitioner will deposit an amount of rupees 50,000 in the registry so as to meet the litigation expenses of the respondent.
Please, Your Lordships, the Honorable High Court has upheld the order of the learned MM, wherein my complaint under Section 500 has been dismissed, Your Lordship. Your Lordship, not appreciating the fact that Section 211 offence and an offence under Section 500 are distinct offences, Your Lordship, and the bar of 195 would apply only to an offence under Section 211 and not 500, Your Lordship. Your Lordship, if two distinct offences, Your Lordship, are committed in the same transactions, Your Lordship, and one of the offence is barred under 195, it does not prevent the court from taking cognizance of the second offence if there is no such bar, provided the two offences are distinct offences, Your Lordship.
Ms. Preeti Singh, how many years after you filed? When were you discharged?
Your Lordship, this was only after a couple of months of my dismissal of my I was discharged, Your Lordship, in this matter.
Her 498 case.
After her 498 case, 14 years is the finding of the alleged allegation.
I'm sorry, Your Lordship, I could not get the question.
14 years after the allegation was made is what the trial court says about your approaching the court.
Your Lordship, what the court is saying is that
His name and that. The only question there is 195 1. Between 211 and 499 500.
Please, Your Lordship. Your Lordship, in fact, 195 does not cover Section 500.
But the law-
If you could just read out 195, this only covers offences with regard to fabricating and giving false evidence and forgery.
But this is a traditional method of disguising 211 or 195 1B bar offences into certain other offences to get over the bar. That the High Court has said nothing doing.
That camouflage of the circumventing would apply only to
Thank you.
cases.
Thank you, madam. Thank you.
Obliged.
28.
May I, my lords? My lords, this is a matter relating to, my lords, my non-traceable certificate that was issued by the police being cancelled. There is, my lords, a factual error that the learned judge has made in the order, my lords.
But is it true that in that suit the original was filed?
Would my lords look at?
That is what the respondent's contention is, that the original is already there in the original suit.
Would my lords look at page 38 that has the list of documents that were being filed with the suit? Page 38, my lords would look at. This is, my lords, and my power of attorney, my lords, is dated 23/4/1992, my lords. At page 38, you would see the plain documents chronologically arranged, my lords. I am the defendant in the suit. My lords would see there is no reference to the 1992 document.
Then how did the government advocate also say that it is authenticated that it is originally filed in that court?
My lords, even it's a matter that has left even me a bit baffled, my lords, because I have gone through the plain documents. It is not available.
Notice.
Obliged, my lords.
The learned counsel for the petitioner says that the finding of the learned and the High Court that the document in question, that is certificate, that the certificate in question is a part of OS, is not gone out of from the record. Issue notice, returnable OS.
Obliged, my lords.
Stay off the book.
Obliged.
Your still valid High Court will not proceeding only by saying that the dues of the bank has been paid and therefore proceeds to quash it. It is a case, my lords, wherein fraudulent documents, false document, forged document, fabricated documents were produced for obtaining the loan. And there is a distinction between this, on the facts in this case and the recent case decided by this bench, your lordship bench, wherein it has been said that in case it's a matter of civil flavor only, then definitely on the basis of the settlement, or if the proceedings are going before the debt recovery tribunal and then subsequently criminal case has been lodged, on payment it can be done. But my lords have held that if the loan has been obtained on the basis of fraudulent documents, fabrication of documents, in that case, it can't be questioned because it has got complete public element and a criminal liability can't be washed off merely because the settlement of the bank has come into play. And this is the case which I want to.
So whose evidence you will get to show all this forgery?
No,
Bank will say we are satisfied. He won't even come with your evidence.
Your lordship will appreciate that. In this case,
We don't understand in why CBI in such matters shows personal interest.
absolutely not. No, no. First, the bank makes the complaint that it has been subjected to forgery and fraud. Now, when the investigation takes place and when the CBI takes action against those persons who are indulging in such criminal act, now they go to the bank and they make the payment either under some settlement scheme they make the payment, and then they come to the court and say that quash the FIR or quash the criminal proceedings. Now, if the CBI was...
Forgery has to result in very valuable security or deprivation of money, even non-economic loss. But then if the person who is deceived or subject matter of deprivation in forgery says that we have no...
the private domain,
You see Vimala versus Delhi administration, those line of cases.
Yesterday I was looking into your lordship's judgment. Your lordships had relied on earlier judgment of Gyan Singh, 3 judges bench by Justice Lodha. Then in that judgment also there are certain exceptions which have been carved out. I will show to my lords immediately. Now, if your lordship will see the facts of this case, facts are so glaring, my lords. Now, he had not only submitted forged and fabricated documents, but he also obtained a certificate of a chartered accountant, which was forged and fabricated.
To get loan from the bank.
Your lordship, for the
purpose. The bank says, I have no grievance as long as he has paid the money, any collateral, etc., has become meaningless now.
No, your lordship will appreciate here. Now, kindly come to page 46, madam. No, page 46, madam. No, 45 first, madam. Paragraph 4. On the basis of the representation dated 26/3/2003, Sri Satya Prakash Gupta and Sri Mahesh Jindal, directors of the company, additional cash credit limit of 1.7017.
Whether that accountant was made accused?
Yes, yes. They have been made.
That
officials and the directors of the company, they are all accused. Even the chartered accountant who was given fake certificate. This could not have been unearthed, this conspiracy between the bank officers and the company, if had there not been a statutory audit report. Now that report clarified that all this is fake and forged. Now, if your lordship will see, A.K. Jana.
He is not an accused.
He is an accused, A.K. Jana is an accused. If your lordship will say the charge sheet, your lordship will find he is an accused. A.K. Jana is an accused.
Where is the charge sheet?
Charge sheet is, annexure, it is P3, page, starts from page 55, 54. He is one of an accused, All the details have been furnished in the charge sheet. Fake certificate, if your lordship will kindly come to page, paragraph 7 at page 47.
Thank you.
Right.
unnecessarily penned, you will not be able to get any conviction on this.
Yes, there are two SCP corrected in this matter, that it is grant of anticipatory, but the line of proceeding was that was opted by one of the High Court was that the entire case is based on a civil transaction, although it is based on civil transaction matter. But there has been a strong criminality undercurrent because in the sale, the agreement to sell itself, he mentioned that the property is completely free from all encumbrances and everything, and thereafter he took 3.90 crores from people. My lord, he has taken all the money, my lord, and that the direction was only to deposit that money before court.
No, that may be excessive, but the relief granted of only severing the condition.
My lord.
There's a judgment of this court which says in which scenario matter has to be sent back for fresh consideration of anticipatory. We don't know how the court would have reacted if the deposit were not there.
So may I pray, my lord, that's the entire matter can be remanded back to the court of learned additional session just to reappreciate the matter of anticipatory case, my lord.
Issue notice, returnable folds.
Should be good.
Lordship, I'm against an order of Honorable Allahabad High Court where they have upheld the order of the learned ASG. Basically, it is related to the charge. The initial charge was framed under
306.
and it was altered to the 302. Lordship, this was basically based on the statement of PW1 and PW2. Nothing new has been done. It was not a very judicious order, I'd say. In fact, the FIR is Lordship annexure to page number 52. This was lost after 3 months. And then the cross examination also Lordship may look at page number 81. Yes.
Arun Kumar's chief.
Yes.
Based on which the 216 was allowed.
Yes. Lordship, may I read?
Yes.
Name witness Arun Kumar, age about 31 years, son Dinanath, resident, Belwa Shukla, Jamman, Parlot, Lokista, Ranipur Police Station, Vidyatop District, Gonda, has appeared and given the sworn statement that my elder sister, Meena Devi, was married to the present court accused, Suresh, about 30 years ago.
30 years.
My sister has 3 sons and 1 daughter. The eldest of Dharmendra was married to Aarti Devi.
Issue notice.
The allegation is father-in-law had an affair with the daughter-in-law.
Daughter-in-law. And the son helped both father.
Son helped father and the daughter-in-law.
Daughter-in-law to murder.
That is why I wanted to read it.
Prayer maybe the stay on the trial.
Stay of trial until further order.
Oh, that's
My lord, I am convict, my lord. I have served more than 10 years, my lord. I have applied for 15 days ordinary leave, my lord.
You are not entitled to parole and
without escort. Without escort, he is asking.
You can apply for parole, furlough.
You want without escort?
Without escort, my lord. This kind of treatment of the mother, my lord. I am 38 years old. He is my lord. And the 2 children are.
Reject. Or you better withdraw it.
So, my lord, I am.
Allowed to return.
Yes.
Only against observation.
Verify that observation.
It is a peace, my lords. My lords, in a quashing petition, a blanket order has been directed with respect to no coercive steps to be taken against the respondents. Now, what is happening, my lords, is the matter is coming on board and the interim protection is being extended, and the petitioner, without moving a bail application, is enjoying this stay and not joining the investigation, my lords. My lords, will kindly see the latest order on 2nd of December.
Apply for cancellation of that interim order.
My lords, the matter is not, it's coming up on weekly list. My lords, will kindly see the order on 2nd December, which has been extended. Now, this interim, it is clearly recorded, number one, that he is not joining the investigation. In spite of that, the High Court has extended the stay protection till up to 28th February. So, whenever the matter is coming in it's on its own. The question, the moot question I'm asking myself, without moving for a bail application, could the High Court entertain, my lords, and pass blanket?
The grievance of the petitioner is that the blanket order under the blanket order of no coercive steps to be taken, the respondent accused is misusing his liberty and not even cooperating with the investigation. We grant liberty to the petitioners to apply for vacating of the said interim order. On such application being made, the High Court would consider it expeditious and preferably within a period of 4 weeks from the date of making it.
Deeply grateful, my lords, deeply grateful. I am obliged.
Lord, my prayer for suspension of sentence was declined. Lord, I've been convicted under 307 for 7 years. But Lord, there are certain mitigating factors which the High Court in my humble submission ought to consider. Lord, there are only one simple injury. This is not a case of 307 at best, Lord. At best, it could have been 326. There is only one injury in the occipital Lord, area, which is a cut, for which the doctor advised X-ray report came, there is no bony injury. There is no injury on the bone. Now, the IO admits that 307 was put without consulting the doctor. But there were 8 villagers who were examined. None of them supported his case. This is based on sole testimony of the complainant. But the doctor himself says that the injuries could have been caused by falling. And his case was that I was on the bike, and when the ambush or the attack happened, I was on the bike and he fell down. There is absolute blood. I was on bail for 14 years. The trial started in
How many days you have been?
4 months.
Only 4 months.
4 months. I am 70 years old. Both live in the same village, adjacent house. I was on bail for 14 years. The trial started in 2010. Conviction is in 2024. No complaint by anybody that I did anything. This is clearly a case of 326 at best. I can show it to you, Lordship. Even the doctor says that the injury I did not look at the X-ray report before giving my opinion.
Issue notice. Returnable 4 weeks.
We also serve the standing counsel, right?
Yes, that is a part of our comment.
What's the question? It's not possible.
This one is a good
We question my password also.
And petitioner this matter was declared the petition to transfer the investigation at the complaint stage itself. Lord Agri Sambu court held that 226 not went up to direct to file the affair. But in spite, this matter regards with the sending WhatsApp message. Let's kindly see what the message is played.
Friends of allegation on social media. So they said,
My lords, stepping on the message, my lords, kindly see.
Thank you, thank you.
Please, Millets. Millets, my only submission is Millets. The magistrate took cognizance in 2020 Millets. Millets only because of the absence of this husband Millets, the respondent Millets. That the trial could not commence till September 2023 Millets. Millets may kindly consider Millets only
Yes,
because
he's staying in Chennai, and as and when he is required for the trial, he will come there.
there is so much delay in trial Millets.
Okay, thank you.
Much please Millets. Right.
Item 39 was listed on 411. Lordship had directed me to attach the vernacular of suspension order.
You not attached it.
I was unable to attach it. The vernacular, our office was unable to upload it. Your Lordship, if permits me, the vernacular of the The suspension order is on page 71, Your Lordship.
No, you have to produce the order closing the inquiry. No?
Yes, the translated one is on page 71. 54 to 71. 71 is the sentence. Page 54. This, the Agra Nagar Nigam had attached before the High Court. Lordships had directed me to attach the vernacular of it. Your Lordship, because I was under the weather last week, I was able to file it. Lordship, if I have the vernacular of this, it's permit. It would make you go.
It's not showing the one.
Page 113 is the vernacular. Your Lordships, do you have maybe 113? Done. अपचारी कर्मचारी अरुण कुमार शर्मा द्वितीय श्रेणी लिपिक की 2 वेतन वृद्धियों स्थायी प्रभाव से रोकते हुए तत्काल प्रभाव से पुनः सेवा में जांचाधीन बहाल किया जाता है. Which means he has been reinstated with pending inquiry. My submission on 4th November was the inquiry has not been completed, Your Lordships. He has been also retired till now.
No, reinstated?
Reinstated, but with pending inquiry.
Pending inquiry.
The inquiry is, this was in 21, Your Lordship.
21. That was the issue.
Oh, but then
Not over.
two increments have been stopped.
2 increments have been stopped. He was appointed as a second grade clerk.
Penalty हो गया एक बार.
If I may update you, he was the Lordship, it's a second complaint.
Thank you.
The Lordship permit me to go against this before High Court.
The learned consider the petition with liberty to withdraw, with liberty to take such steps as are permissible in law.
Obligation.
Item 40.
Your Lordships, I'm paying for a password in the matter.
Yes.
Password in this matter.
It's against enforcement.
So that
This page 47, P6 in 47, 64.1.
Because they say that you apply for next year. Our case was that they are not converting our previous year recognition to this year. And if the losses will recall only objection, Mr. Kumar, to us that we are not allowing inspection. I informed that not only inspection we are willing, but surprise inspection should also happen. They don't come for any clarification, then send an email that you apply for next year. Please see the email was at P6.
Is here, get treated as IA.
Yes.
Lordship, out of 40 colleges, my lord, 3 has not applied, my lord. For that, my
No,
lord.
but then he says that you don't hold inspection and all of a sudden you send that for the.
In one college, my lord.
We are not.
They are not circulated the contempt.
You give a copy.
Plus, I will give you a copy. In first matter, plus I came to this court that we had given plus after inspection, they pointed out deficiency, I gave reply. The lots is directed to decide plus within cutoff date, which is 25th November. They have not done anything.
That has been rejected, my lord. I'm sorry. That has been rejected.
No communication, nothing. I don't know where they rejected. And in 2+64.1 and 64.2, they said you apply next year. That's the email they have sent after the cutoff date on 29th. We have specifically pointed out that only objection, if losses will recall, they took plus a day prior, Mr. Pandey had filed a writ which is losses disposed of, directing them to decide loss where there was no application. Given
Monday.
How many? Yes.
I'll supply it.
Apply. Issue notice, reasonable Monday.
Ordinary losses consider this Friday.
Friday maybe.
Because we have absolutely no difficulty, if we must fulfill norms, they should
Yes.
inspect and let's give us. This is an existing institution, they gave last year approval. I will serve a copy.
Let's see.
Good.
She was to appear on the screen.
Your Lordship, I am Chavi Goyal.
She's there.
Your Lordship, as suggested by you, I am willing for mediation.
Lord, that's something I wish to just know that it.
Catch your breath first.
Yes. Lord, this 5 minutes of your Lordship's time, since we are, my lords, happy to do what your Lordships think is reasonable. I just want to give a little perspective based on what is on record. So just bear with me. I'll read it aloud so that my learned friend can hear it. But just an overall perspective, and then whatever your Lordship say, my lord, we will abide by. Two copies. I'll read it aloud so that she can hear everything. My lord, overall, just so that your Lordship know the scope. The settlement agreement dated 1/9/2022 was entered into pursuant to the mediation conducted by a counsellor of the family court, Saket, in light of the order so-and-so passed by the family court. The settlement agreement is a meticulously drawn up document that encompasses not only the divorce to be obtained, but also a full and final settlement of all claims and withdrawal or quashing of all 20 proceedings pending between the parties, including the subject criminal proceedings under Section 498A. Both parties recorded a joint statement, and the respondent wife filed an affidavit cum undertaking reproducing clauses of the settlement agreement before the family court. Family court, in order dated 14/9/2022, more than 2 years now, recorded that both parties will be bound by the joint statement. It has never been the case of the respondent wife in any proceeding or hearing before, and I'll point out where, that there was any coercion or any kind of undue influence or pressure that culminated in the settlement agreement. This was raised for the very first time only after the learned senior counsel on her behalf concluded arguments in the appeal in the contempt proceedings before the Honorable High Court at Delhi on 18/11/2024. My arguments are yet to happen in the Delhi High Court, but this was for the first time. On the contrary, before the learned single judge, this is the Delhi High Court, it is stated that she had a rethink
only on account of the fact that she wanted a more, and I'm quoting the Delhi High Court, lucrative financial settlement. My lord, the settlement transferring the self-acquired flat of the petitioner husband is a two-bedroom flat in an upscale premium location in Mumbai, may be seen in the overall perspective. The marriage was very short-lived. Parties lived as husband and wife only from 25/7/2015 to 6/4/2017, less than a period of 2 years. They have been living separately for more than 7 years. In Shilpa Shailesh so-and-so, it was held that a separation period of 6 years or more would be a relevant factor for granting divorce under Article 142. The petitioner husband was compelled to leave his own home in Mumbai along with his autistic son from a previous marriage and relocate to Faridabad. This was his self-acquired property of the husband. The respondent wife continued to reside there and her parents have moved in with her, thus giving her exclusive possession over the flat, which she continues to enjoy. In her previous marriage, divorce was granted to the respondent wife by mutual consent and she has obtained rupees 20 lakhs vide an order dated 28/7/2012. The respondent wife is a lady of means who is highly educated, holding engineering and MBA degrees. She was working with ICICI Bank as a manager and resigned only in May 21 to obtain interim maintenance. In her resignation letter dated 27/4/2021, filed in the contempt case before the Honorable High Court of Delhi, she has claimed that she resigned to pursue litigation. The respondent wife has been convicted by the learned single judge of the Honorable High Court at Delhi for violating the consent terms. Learned single judge gave her the opportunity to purge her contempt by executing the gift deed, paying the maintenance charges and undertaking not to proceed with legal proceedings in terms.
Gift deed with regard to?
Lord, the settlement is the full and final settlement is this flat, 2-bedroom flat in Parel, very upscale. It's the value according to us is 5 crores. She simply had to pay. There was an outstanding loan of Lord, 10 lakhs.
10 lakhs, which I paid.
I'm sorry, just madam, let me just finish. 9 lakhs was the loan and 13 lakhs approximately were the outstanding maintenance. She was living there since 2017. I had to flee virtually.
DV order.
Just a moment, madam, I'll just finish. It's one more paragraph. She, she did not do so. That is, she didn't pay the maintenance charges. Instead, she filed an appeal. In the appeal, the conviction has not only been stayed, only the sentence has been suspended. The appeal is pending and part heard where she has acted through a senior counsel. It may also be noted, this is also important, that this Honorable Court, vide the order dated 4/5/2018, transfer petition so-and-so, directed the parties to mediation and appointed Ms. Vibha Datta Makhija as mediator. There were 5 dates given in the mediation and the respondent wife only appeared personally for 2 dates. The mediation failed. This Honorable Court, order dated 28/5/2020, directed that various matters, including the divorce, that were the subject matter of the transfer petitions, be expeditiously completed, preferably within 1 year. So, that's where we stand today. The settlement is more than now.
This order dated 28th of May 2020 arises out of the Delhi High Court proceedings.
No, my lords.
No.
Can your lordship just repeat that question, please?
No, this order
Yes.
dated 28th of May 2020 passed by this court.
Yes, my lord.
Arises out.
Transfer. The transfer petition. She asked for transfer, that was denied, or sent the parties for mediation. And there were 5 dates given by Ms. Makhija, I understand. And my lord, her report would be there. But my lord, I don't want to say any more, but there were 2 dates where she attended and unfortunately it did not work out. There is, my lord, subsequent to that, only security for my autistic son, which self-acquired flat. I had to flee virtually with my young son. He's now in his teens. I have to provide for him. And I'm standing by the settlement. But what I'm trying to say is I really stretched myself because I was so miserable and I want to be out of this situation. And
my lords, I was informed that it is for mediation.
We'll call upon you.
To put an end to all these criminal 20 proceedings were there. 20 are there, and my lords, in this particular 498A, the arrangement was under the settlement, which is on record, that once the decree for divorce is granted, then immediately after, my lords, this will be quashed. That was the understanding between us. And it's recorded, it's recorded in terms, joint statement, affidavit, come undertaking, everything is there. She doesn't want to be back in the marriage. And in the interim, no matter was to
Feeling that if the gift deed is executed in your favor, it will.
No, it is not executed.
Can we complete our question?
Gift deed is not executed, sir.
We are asking you if the gift deed is executed in your favor.
No, sir.
Are you willing that proceedings shall be?
Actually, sir, I need maintenance. I am an unemployed lady. My parents are suffering from cancer. And yes, sir. I want to. Yes, sir. Can you read page 25? Please give me the opportunity to speak.
Thank you. We'll hear you finally.
I was told that today mediation will happen.
We also came to know what happened in the court after we left the court.
But I was not allowed.
In which you should deal with the opposite side lawyers.
They have written the discharge application in MM court and they are asking for FIR question.
Know what has happened in the court on the last day, Friday, after we had left the court.
What, sir?
Hello. Next one.
This is the recurring problem of persons having valid certificates and those having conditional validity. On verification of their claim of being a scheduled tribe, because your lordships are aware in Maharashtra, the scrutiny committee takes enormous time, but it works to the disadvantage of people like us who have valid certificates. We are in the NEET MPG merit list. Those with conditional validity, well, they steal a march because they get interim orders from the High Court.
Oh, but here there is not a question of interim order. There is a certificate of validity in favor of her father, Namdev.
It has not been cancelled.
No, but it's been cancelled.
No, it is not cancelled.
That is the finding.
Her certificate has been cancelled.
Her certificate. So therefore the High Court is right. It can't be that the father is a scheduled tribe and the son is not a scheduled tribe.
We are not on the merits of that. What we are saying is this. Your lordships will see Annexure P8 when a similar problem came up before this court. No, Annexure P8, if my lords will see. Well, as the father's certificate is also under scrutiny, my point is something else, my lords. My point is only this. We are people with valid certificates, no doubts at all about our certificates. There is a whole batch of people whose certificates are in doubt, they are before the scrutiny committee. My lords made a distinction between these two categories, which is why I am pointing out to Annexure P8. Because it makes a lot of a difference, my lords. If people with only a conditional validity through an interim order are getting admitted, well, they end up completing a whole course.
But suppose tomorrow their conditional validity is affirmed and they are held to be valid.
No,
what happens in that situation?
Which is why we have to balance equities. Which is why I'm saying that. I'm not for a merit questioning.
You are much below in the merit list. It is not.
Apparently, it does not work like that. Well, that's
you are 75, 73, 56, and 49.
Please, but apparently there are multiple options. This is what I got a detailed instruction on this. If one person moves out who's above us, our chances get far greater and we're able to select among the different colleges. So our chances go up. Well, year after year, this problem is occurring. Your lordships, Annexure P8, if my lords will see that. Your lordships anticipated this and said that the High Court should give a time-bound order.
Page?
Well, it's page 89. Your lordships fixed a time limit for disposal of their claims before the scrutiny committee and said only those who have got successful in the scrutiny committee, page 91 bottom, if my lords will see, as 11 students have become successful, we direct the institution to admit those 11 students in order of merit after counseling. The other seats shall not be filled up and they shall be filled up after the judgment is pronounced by the High Court. The High Court shall not pass any protective order dealing with the writ petition. Before parting with the case, we are obliged to state that the divisional bench of the High Court has been absolutely ill-advised to pass such an interim order. The same is hereby set aside. Then they asked a special bench of the High Court to be constituted, only to balance the equities. What happens, Malas, others failure to comply is presented. Your Lordship is absolutely right. There could be a set of cases where their claims are actually apprehended. But there could be a set of cases where it's not. Then how do we balance what happens with people with regular certificates which has not been in doubt at all, not under challenge at all? They completely lose out.
Thank you.
Well, would your Lordships then permit me to, there is apparently a pending petition here. I'll just take my chance because on this very point, there's a petition since 2021. On this very point in which notice has been issued. I'm not asking for any relief in this right now, Malas. If it can just be heard along with that, because it's the same.
You file an intervention in that.
Will your Lordships then permit me to withdraw this to file that? I withdraw this to file an inter.
Allowed to withdraw to file a intervention application in a pending petition.
In the pending, well, I'll give the number so that.
Give the number.
Very good. I'm obliged.
The two poets who were granted bail was because the only evidence against them was of CDR. Not the present applicant, my lord. He is actually the driver, and my lords, in that, my lords, the contraband were found. And without considering, my lords, the rigors, my lords. And there are only 5 witnesses. One witness is already examined. My lord, trial itself could be completed in around 6 to 9 months.
And who is the owner of the vehicle?
He was driving.
I am driver.
He is the driver, but who is the owner?
There's some third party.
I am not aware of it. To take instruction on that.
Only 5 witnesses.
Taking into consideration the stage of the trial, we are not inclined to entertain.
Lordship, I am behind bar from for 2 years, 3 months, and now it's more than 2
We
years.
are not inclined to entertain.
Only one witness has been examined. That's witness.
However, the learned trial judge is requested to expedite the trial and conclude the same within a period of 3 months from today.
The Lord.
Lordship, the next date is given in March. That the next date of evidence for
You
evidence.
you place this order.
Place this on. Obliged.
Lord.
Application taken on board. None appears, though called out twice, dismissed. Yes.
Seeking regular bail matters. The petitioner is inside since 14th of September 2023. Can I indicate what has happened? In a flat in Bombay, there is a partition between 2 cousins in a flat. Disputes have been going on for some time. On this 13/9/20.
Very strange sort of relationship. You go for a ride together in a alto and.
Yes, and suddenly what happened that day? Some dispute was going on with my father. The lady herself says so in her 151 statement. And perhaps what happens, he had a knife and there's a small 2 centimeter by 3 centimeter injury in this side of her chest, of the lady's chest. So that's the injury because of which I have suffered now 1 year, 3 months. Father was granted bail saying you will not enter there. Our families now, of course, because there is estrangement, but it's not some intention to cause a death. It's not a 307 because of which because no criminal antecedent is working in a bank. Some dispute because between the two sister-in-laws, there was some dispute which spiraled. Therefore, just have that evidence of the lady. She says disputes were going on, and suddenly, the husband came, and therefore this has happened. So I was requesting page number her statement because the lady was page 167 onwards. Lordships will see the entire statement. Lordships are absolutely right. 167. I am reading the 161 statement of the victim. 167. The Lordships are absolutely right. There are outings between the family members. They are 167 Lordships have. In our next door, my cousin father-in-law Charu Datta. Charu Datta Patare is my father. Stays along with his son Sridhar. I am Sridhar and his wife Komal. On 25th December 22, the entire family 25 went for an outing to Nakshatra farm. At that point of somewhere in the swimming pool, some of me, my husband and my other relatives are passing football to each other. At that time, my brother-in-law Sridhar was standing on the ledge outside the swimming pool. At that time, football came out of the swimming pool. At that time, Sridhar was expected to pass the football to play in the swimming tank. But before I knew it, he threw the football at my face. I had a swelling into my left hand. Sorry.
You implement the
Yes, my lord. If the lordship will issue notice, I will implead on my oral request. The informant is the husband of the injured. So the FIR gives the details. Lordship on my oral request implead.
the first requirement as party respondent. Issue notice. The amendment will be carried out for issue notice. Written about 4 weeks.
Can I serve the standing counsel?
That is part of our format.
Yes. Obliged to lordship. Short password.
This is the second password.
CL was added to court in 60 minutes. Kindly short password minutes.
Who is seller?
Seattle will not do. Kindly short password wait.
Okay.
Very pleased, Your Lordship. With the greatest respect to the High Court, 70% of the judgment is not discernible. And I will read out one paragraph to Your Lordships, my lords, for that.
That's not only in this matter.
There's nothing, I can't, look, it's difficult to make out.
Notice. Have you been taken inside?
I've surrendered, my lord. But please see page, there's nothing, I can make out anything from the judgment with respect to this. May I have to go back to the High Court, my lord, with respect.
My lords, I appear on behalf of the complainant, respondent number 2 in this case. My lords may grant us 6 weeks time to final reply.
Please grant.
Considering 2 weeks of holidays in the middle.
Please see paragraph 26 for a moment, page 26, paragraph 33. I'll just read, my lords, for your lordship.
Are you in a position to understand that English?
No, my lord, that's what I'm saying. There is I don't mean to make anything, but with respect, I'm stating, my lord, if there is a reversal, at least the convict should know on what ground the reversal has taken place. Please see page 26, paragraph 23. If I may read that, my lords, be that as it may, if upon a prosecution case rested upon eyewitness account, the eyewitness concerned resides from his previously made statement. Moreover, also upon being cross-examined by the learned PP concerned, thus the judicial conscience of the court becomes completely satisfied that the investigating officer concerned did record thus a fabricated apposite previously made statement in writing. Thereby the court would
notice.
The second appellant, he's not an army man.
No, he wasn't an army. Allegation is that first one had the pistol, fired from that country-made pistol. This one took it, fired from him, and not only there are 2 others who are coming in the pipeline, who were also in the army, present in the army. Actually, it was a case of blind murder. They did not know who has committed this murder. And thereafter, this and his court of inquiry was held. His number of defense.
No, defense witnesses have said that he was at the center. But will that apply to the second appellant is what I must.
No, it won't.
That was the only, but then.
As far as the alibi is concerned, as far as the alibi is concerned.
You should notice reasonable 4 weeks. Have you made the complaint as party respondent?
Okay. No. Not party.
You have to give the first informant as party respondent. You should notice of standard level. By identity orders, the judgment and by way of identity order, the judgment and order of the High Court is state the appellant is directed to be released on identity bail on the same terms and conditions. Whether you are on bail during trial.
No, my lords, they
No,
are.
I've been acquitted.
During trial.
Sorry. My lords, if I make a provision, if my lords are granted bail, may.
It will hear you after.
My lords, if you're granting bail, then my lords may keep it for next week. You may engage a senior to assist the court.
That won't make any difference. At least in this court.
My lords may please keep it for next week then.
Leave granted. The judgment and order of suspension. And sentence is straight. Argue it after next November.
My lords may grant us permission to file a reply.
What do you want? You want a notice or leave?
Leave. Notice of course.
File your reply.
Much obliged.
Council is on his legs and I'm going to put one password.
Okay, what is this?
He's on his legs, madam. Can we pass on at the end of the meeting? I'm sorry for the inconvenience, boss.
Nothing in the matter. What is there in the matter? Anyway, yes.
Doing this entire transaction, may I just hand over a chart explaining what the transaction is? Because the High Court cautions against 4, does not caution against the other 4.
But those 4 are your creditors financially.
Yes.
Yes.
And the allegation is, which is now borne out by the charge sheet. Now the High Court does not call for a counter or a status report, with respect. Within 2 days that charge sheet is filed, and charge sheet is replete with the aspect that the money has come back. It is my money which has come back to this bank, which is to pay off some other loans. Now please see, my lords. Now this GMI Finance is this. GMI Finance, please give them also copies. GMI Finance Private Limited is the bank. Now this SIPL is the company in which I, as the Abhicom, has 85% shareholding, but no management control. This loan comes from this GMI Finance. It goes to this Keystone Developers, who is the builder to construct for this company, SIPL. Now this money comes from there, and on the side I said, he diverts the loan to Keystone for 33 crores. This Keystone in turn gives it to his own company, Stellar Spring Projects Private Limited, which is 33 crores. Stellar Spring gives it back to DMI Finance, this 33 crores, which is the diversion that we allege. And this proof is there, my lords, because the High Court, with respect, as I submitted to before your lordships, did not consider calling for either a status report from or counter affidavit from the state. Had it been done within 2 days of this quashing, my lords, the police filed a charge sheet. Of course, they could file charge sheet against all the people appearing on the other side, but filed against those 4 persons, and it is replete with that how this diversion has taken place. Now, I'm in a quandary, my lords, now, because if those 4 have to be proceeded and they are in conspiracy for diversion, then the ultimate beneficiary of that, those funds that were being diverted to, will have to be there as the accused persons. Now, with respect, my lords, it was incumbent upon the High Court, my lords, to call for at least a status report when the case had been, the FIR had been registered, my lords, as far back as, my lords, 2021, my lords.
To come to para 40, page 45, para H.
The two letters, first sanctions letter of DMI Finance dated 2/5/2008 and second the shareholders agreement cannot be held to be forged document as informant itself has acted upon these documents after undertaking contents and signing the same and actually taken benefit in terms of these documents. A loan amount of 55 crores and 9.80 crores was disbursed to the informant and the companies of accused A1. Once the informant company itself has signed these documents and after acting upon the same has taken huge amounts from DMI Finance, the lodging of FIR on the ground that these are forged documents is misuse of the process of law and is a novel way to avoid repayment of loan to the informant company. Therefore, offence of 467, 468, 71 is not made out against petitioners A to 5 in view of the decision of Bharatish Reddy versus Lalit Chaturvedi. Now, the allegation is
I also read it.
I'll come, my learned friend may, I'm sure they are eager because I'll read everything. That this is yet another aspect that which the Chief Judicial Magistrate, by passing the impugn order, did not notice that the dispute.
You are reading.
My learned friend wanted me to read I at page 46.
IGM notice a clear breach.
This is the civil part, but another aspect which I'm reading it, my learned friend may have some patience, I'm reading it. There's yet another aspect which the Chief Judicial Magistrate, while passing the impugn order, did not notice that the dispute is of civil nature. And from 2018 to 22, when FIR was registered, the informant itself was acting upon the same and taking loan installments from DMI Finance. And after 4 years, the present FIR has been registered against DMI Finance as well as other co-accused, and therefore the impugned order passed by CJM directing registration against the FIR is not sustainable in law. That's exactly the point. Now, please turn 100 of the additional volume. Now, I'm sure my learned friend will read all of that.
I started NCLT proceedings and they went and ran on to
J he should have read, bro. J is very clear.
Depending on my law.
Can I complete my argument? So my learned friends want to stymie that also. I'm not dependent on you whether I've had enough or not. I can add on myself. You please do not be Mr. Logi.
So far as I am concerned, I am a lender. I haven't got a penny back.
You want the 100 crores rooted through the other company to pay off some other loans. Please see page 100.
After the NCLT, you come and do this.
I don't understand this. Why my learned friend
moving this building?
Why is my learned friend interrupt me? I have not finished my arguments. Only you get a start. Bogus. Yes. Just because you say so doesn't mean it's bogus. Page 100, my lords, different contents.
We didn't have any fireworks in the morning.
I'm sure, sorry. Would have been more, my lords, if Mr. Luthra was physically present.
Nobody there.
He's hidden himself.
I'm here. I was here in the first call when you were missing, my friend.
Those different contents, page 100. Now, I am only showing, my lords, if the High Court, if the FIR is of 22, and the judgment and the order of ours is 31A. Surely some counter affidavit could have been called from the state as far as the progress of investigation is concerned. And if it the allegation and the investigation has found that there is diversion of loan of the money of the installment that will go back from the loan that I have paid, that entire 33 crores have gone back to DMI from another entity. That is what is in the charge sheet below, which is what my learned friends clients don't want to come. That is the difficulty. Please have 100 and 101. I'll show from repeat with the charge sheet.
What?
Yes, please see 101.
Of the main point.
Of the additional the charge sheet which I have taken liberty from your lordship last time. It's filed within 2 days of the court order. That means the charge sheet was ready and the police was going to file that charge sheet and the High Court.
No, it is there, it is there.
And then one of the additional documents.
This is the charge sheet which we filed, and this is part of the case diary which is annexed to the charge sheet. that at E, now this is the client, my learned friends are all represented.
101.
101. And I will take various other pages. DMI, for whom they appear, had disbursed a loan totaling to 23.88 crores till 31st March 2019. However, as per AFS dated 31/3/2019, capital work in progress, including interest during construction, is 23 crores 18 lakhs. It overtly proves that 60 lakhs has been diverted by the borrower with connivance of DMI Finance. Besides the same, the work order in favor of Keystone Developers Contractors says all work shall be executed by the contractor, but scrutiny of books establishes that only 17 crores 59 lakhs are in bills which have been raised by the contractor. Hence, balance of 559 lakhs is diversion, misappropriation of funds, which may be proved as under. So this is the finding in the charge sheet, the allegation specifically. Now please see 108. I may only.
Page 95 says case diary details.
Yes, it is part of the charge sheet, the case diary.
No, but you show the summary in the charge sheet.
But
No, case diary is not a part of charge sheet.
here it's filed as part of the case diary.
On the contrary, the case diary
it is peculiar.
only for the purpose of the investigation purpose, and nobody else except the court is entitled to have a look at it.
They filed it with the charge sheet.
Oh my God.
It is charge sheet. This is part of the case diary. It is filed with it. But I may request my learned friends' comments to be a little either low, so that I may not hear it much as he wants to, but I allow me to argue. That prayer is to your lordship. So this is part of it. This is.
You show the charge sheet.
This is all in the charge sheet conclusion is.
No, the gist of the
Charge sheet says no case against him. No? Hindi version charge sheet says no evidence against me. Page 29. On page 29 it says suspicion approved nahi.
Page 20.
29, not 29 in the charge sheet. Please see, even against Shivashi Chatterjee, suspicion approved nahi. Please see the Hindi version, Roman 11.
Is very, I may put it smartly saying, against these four persons, it stood court.
And 30 saksh ke abhav hai.
So obviously.
29 and 30.
I mean, here, I am.
Column 14.
Point out from the summary of the charge sheet as to what is.
Just see column 14 at page 30, Lord. Just see column 14, page 30.
Lordship may ask the state whether it is correct that this case diaries were produced along with the charge sheet or not. This is how we had it once it was filed, along with the charge sheet, the case diaries are filed there. Summary is only one paragraph there, which your lordships have also noticed about and passed various judicial orders that how state of Uttar Pradesh, Madhya Pradesh. Uttar Pradesh, Madhya Pradesh, my lords. Uttar Pradesh. Now I have one prayer, Lord, that if material does come in the trial, the order will not come in the way, my lords, under 319. That clarification, your lordships, should this court make.
The law is there, the law is there.
Sorry, we are not inclined to interfere with the impure orders. However, we clarify that in the event during trial, any material comes against the accused who have been discharged,
Needless to say.
the finding of the High Court would not come in the way of any proceedings that any of the parties may file.
The accused against whom FIR is cautioned.
Against whom?
FIR is cautioned.
Any person.
Or for any person.
Any person.
Any person. But for them, the findings are there, so that comes in mind.
But that has also been separately settled. No?
It has, but some, because these find. Again, the moment 319 comes, the High Court caution that couldn't be summoned because there's already a finding recorded by the.
No, but that has been held. It has been held that notwithstanding the wash or discharge, 319 can be independently.
In fact, 319 doesn't even apply to a 300, or if there's an exception that for a discharge doesn't apply. But for a caution,
the clarified.
I was 13 and went back to the G lottery and city pass over.
I don't know why some people against.
No, this is some other idea.
Yeah, I once for substitution of the AR. And the application for it was listening of 7th of January.
AG तो 500 कर लेंगे 500 का AG का AG is appearing to pass it over.
Okay. Settle.
Yes, sir, we settled on a joint application.
Lordship, there's a joint application filed. I'm appearing online for the petitioners in 2 SLPs.
Settle out of court correction.
Lordship, there are 3 SLPs filed against the impugned order.
I am for the complainant.
It's a long settlement.
Yes, my lord. My lord, the settlement, my lord, because my lord, the nature of the allegations was likely commercial, my lord. So, my lord, we
Yes.
are not settled. My lord, we don't wish to, my lord, I mean, my lord can wash it, my lord, it will be over here.
Lordship, I can point out in so far as the pending proceedings where in the settlement that's listed. It's at page 28, the application.
What are the sections involved?
Lordship, 420, 406, 34.
Non-comfortable. Injustice of the jointly report.
Are you the parties have filed? Criminal MP number 253839. In the light of settlement agreement dated 17th of July 2024. The settlement agreement is taken on record. The statements made in the settlement agreement are treated as an undertaking. This court, in view of the settlement between the parties, the FIR number so and so, dated so and so, grants caution citizen, regulars, even.
Lordship, just wanted to point out that there are 3 SLPs pending. The petitioners in the first 2 SLPs are the ones that have settled, but the petitioner in the 3rd SLP has really no role to play, and the complainant, I've been told, has no problem if the FIR is forged even go ahead.
He was a mere informant, my lord, in the sense.
He was a mere intermediary.
Which are, where is the settlement in?
My lord, it's in the joint application that the parties have filed, my lord. So the IAR is listed today. It starts from page.
It is in SLP number 155, 46 and 47.
Yes, and there is a third one, SLP 3574 of 2024. That is by that intermediary. That is, however, not listed today since he's an intermediary.
We will list it somewhere in the next week.
Yeah. Your Lordship.
I am here, the complainant is here.
You have no grievance.
Yes, sir.
Yes, no grievance. I was just pointing it out for your Lordships.
He was merely a middleman, my lord, who introduced me to the applicant, the financial applicant.
SLP number so and so is taken on board. Who is the petitioner there?
The petitioner is
Sood.
Mr. Vishal Satinder Sood.
You know the petitioner in there. Oh. Let it be listed in the next week.
No, I give it to my lord.
Give the number, we'll have it in the next week, yes.
Okay.
Yes, Your Lordship.
Lordship, on item 15, I beg to appear for respondent state of Bihar, Lordship. I'm requesting 2 weeks accommodation to file counter affidavit, Lordship.
Has come our instance for modification order dated 17/5/2025-24, by which this court has granted stay.
Let them file reply.
Please, Lord, even in the counter affidavit, they have pleaded many new facts and annexed many new documents. In fact, the office.
Unless the matter is heard finally.
Some
It can't be vacated now.
It may be heard, sir.
I'll file reply to the application,
Because-
and they should
because
apply
they are-
counter affidavit.
Yeah, because the respondent number has already overreached.
Okay, let him file it.
Lordship.
File counter.
Lordship.
Some date may be fixed, your lordship.
They'll get after it.
Some shorter date, your lordship.
3 weeks is, what shorter can it be?
I have to write, I know.
So 1960, your lordship had heard us and granted preventive detention has been been given default bail in the matter. They have not filed a charge sheet of 8 months. Have been granted default bail by the trial court.
Yeah, now it is extended by 9 months.
March 3rd.
By 3 months, up to March 2025.
Consequently, you will see that. We'll have it for hearing in the immediately after.
Consider staying it. That's because
granted
default bail in this FIR. The entire detention is based on the FIR. I've been granted default bail.
They have to counter on this because you want the challenge in this very petition, so that is understandable. So they need to.
Because they filed a counter in the petition itself.
For the extension. Your grounds against the extension.
There is a judicial order granting default bail because they have not even filed the charge sheet now for 8 months. But your lordships are well that even an incomplete charge sheet can't be used to deny default bail. Now let's to use preventive detention to deny default bail to someone else.
The application to be considered along with criminal appeal number 1. So, how do you direct the appeal? We preemptively posted for hearing on 22nd of January.
Please, sir. It was 9 months.
14th of January. 16th of January.
Please, sir.
In item 42, I'm requesting for some accommodation in issue. I got the file day before yesterday only. I have recently filed the wakalatnama for petitioner.
How do you get over that brother's evidence? Two of them have taken.
The lordship, I have to see the trial court record. Actually, I have recently filed the wakalatnama.
Next week.
Your lordship may give me 2 weeks here, because I have to get the file from trial court and everything.
You not even admitted. You have to satisfy us how the evidence of that Ganga Vishnu is not.
What document which has been filed in the SLP is there? There is evidence of Ramji and Bhudei. They are the person who first saw the victim.
Okay, 18th.
Recurring cases of this type are coming. Series of judgments by your lordships. And in fact, if I may hand over a compilation with the 3 judgments, I'm much better off than these. How can it be, my lord, she says 6-7 years, there's consensual relationship. How can it be 376 2N?
Who is appearing for the complaint?
Your lordship, I am R2 for complaint.
You'll have it on some NMD. You'll have it on my NMD.
But madam, one request is I am told that he's posted as a BSF constable in Kashmir right now, and NPW has been issued. No coercion.
He is not appearing, my lords. Charge sheet has been filed.
No coercion.
Your lordship, may I say something?
Yes.
He cheated my lot and disturbing my all family, lordship. And due to this incident, very uncomfortable in my society.
He has raised a point about false promise and bona fide promise which could not be fulfilled.
Your lordship, in his own handwriting, made on a stamp paper that he will marry with me within 6 months. After that, he married with another girl, your lordship.
Already married.
Put on a NMD after vacation. In the meantime, no courses will be taken against the petitioner.
I appear for the respondent number 1 state, Madam. I seek instructions, however, upon a prima facie overview of the case details, it appears that the accused number 1 husband has been acquitted.
Has been acquitted?
Yes, madam. So this is as per our
Research. Then what remains?
also for non-prosecution. And also no incriminating evidence because the complainant failed to prove things.
No, the trial have not concluded, Madam. Even the evidences are there, Madam.
The learned counsel for the state.
But my lords, they may clarify on that.
State informs that the trial has already been concluded, in which the main accused, that the husband of the present applicant, present petitioner, has also been acquitted. The learned counsel of the petitioner to take instructions in that regard.
We can have also seek further instructions.
Mediation,
Hey, what mediation? If the trial is already over, what mediation?
Madam, watched against the other.
Will not even when the parents will not. Dubai also will not stay there for 2 months. He was
Put it after 4 weeks. Clearly not physical evidence. Reservation. Oh,
Item 45 appear on behalf of the respondent state. Madam, we filed the counter yesterday. Madam, we're giving a week's time. Madam, it will be on record. We already filed it yesterday.
I will next week then because the total sentence is 12 years. He has already undergone 8.5 years.
Next week.
Item 46. This is the case of singular default of when petitioner counsel has not appeared before learned trial court. This is a complaint case filed against police officers who have extorted and beat him, and filed a false case against petitioner, your lordship. Even respondent state has filed a counter affidavit admitting this fact, that I have emailed to superintendent of police and DG police, but they have done an investigation without issuing notice to me, and therefore I filed a complaint before learned magistrate. That complaint was dismissed on non-appearance of petitioner counsel, your lordship. Thereafter, your lordship, petitioner is approached learned session court. Session court has granted liberty to petitioner to again approach learned trial court magistrate, but the magistrate has again dismissed the matter. Then, your lordship, petitioner is challenged before Honorable High Court, and Honorable High Court has again dismissed the writ petition. My only contention, your lordship, is that the merits of complaint are still to be adjudicated, and your lordship, this is a singular default covered by lordship judgment. Your lordship may remand the matter back to trial court. And the police officers who have been served have not even entered appearance. Respondent number 2.
Argument has concluded the inquiry. After inquiry, this has been intimated to the murder petitioner.
What?
That's they had made a complaint against some police officers. They had made complaint against the police officers on murder 13th September 2017 murders. Through an email. There's a different department for the different district police officer, additional superintendent of police has conducted inquiry.
What has been found in the inquiry?
Yes, no?
What has been found in the inquiry?
There's nothing in the murders. It has been emits murders at page 79 murders. Page 79.
I have specifically stated in my rejoinder also, your lordship, that they have not even issued notice to the circle officer which conducted an preliminary inquiry, has not even asked me to join the investigation.
The police of nine.
No, that inquiry was not a party.
No, but that inquiry, how it can not serve, because they had made a complaint with the police department, my lords. There were some police officers, my lords. So we had conducted independent inquiry, my lords.
Listen on proof.
Put up on NMD.
You get law on this 256.
Lordship, covered that. Lordship can.
Okay, we will have it on NMD.
Yes, Your Lordship. This is the petition for granting the remission, Your Lordship. At 22 years, I have served for 22 years.
Yes.
Was convicted of the act of pilots and the appeals were dismissed by the Honorable Court also. The opinion of the convicted court is pending, so I am seeking 2 weeks time.
What is pending?
The opinion of the judicial opinion of the convicted court.
Put a walk vehicle.
Assessment for 1920 still pending. But it was some time, my lord, to verify the status and then get back to you. And agenda 4 weeks.
We'll admit it.
My lord, it's actually a short point. If subject to their verification, if for one of the subsequent assessment years, they have accepted that we are entitled to treaty benefit. If that is the case,
They are entitled to
treaty benefit, the Indo-Mauritius treaty
Mauritius.
benefit, in which case tax would not be deductible. Then the matter, it's a short matter, it can be disposed of.
So after vacation.
After 6 weeks.
After 6 weeks at the request of Learned ASB.
Right.
Lord, item number 49. Notices issued through publication, Lord, so I am appearing first time after notice. Your Lordship may kindly afford me to file a reply. It's a short issue, my Lord, so any short date may be.
Now, the question of law on whether this statute provided any remedy to the schools to recover the money. I filed a suit. If declared, the appeal was filed, appeal was dismissed, their appeal. Second appeal, the court holds that then the provisions provided in the Haryana Education Act and the rules provides a remedy and says suit was not even maintainable. And this was all the suits.
Anyway, we want an opportunity to file.
Lord, even why the suit is barred, Lord, under section 22.
Is there a clear ouster? That's what he's arguing.
No, it is a clear ouster. It is clear any matter incidental to or not related to Haryana School Education Act and rules, not is clearly passed. So if the suit is maintainable.
Is the remedy of recovery of fees contemplated in the act? It can't oust something not provided in the act.
No, it is not that. It is prohibited, my lord. It is not that the act is silent. I can understand, my lord, if the act is silent. 22 says, my lord, the specific bars, number 1. Secondly, my lord, to make any claim actionable, the law has to be, my lord.
Relevant counsel, senior counsel appearing on behalf of the respondent, 4 weeks.
4 weeks.
Time to file his counter. Put up to 4 weeks. On a NMD. On a NMD.
So take your best. Take your best.
There's any fix yet, I'll tell you about it.
We have told them that it will be on a NMD, yes.
The difficulty is that the boys have not paid the fee for years together. Then the school decided to file the suit itself. Having filed the suit which was declared after 6-7 years, they were fined and those were dismissed. And now we have other set of the suits pending in court. They say you get an order from Supreme Court and then only would proceed in those matters. The suits,
Wait for 4 weeks, nothing will happen.
Grateful.
Work up the law, Mr. Tiku, because we need judgments on this. Whether it's ouster, implied exclusion, Dulabar.
GAVAI is the judgment bill of 1968, Lordship will be aware. The same rule has been followed. If your Lordships look at jurisdiction question, 22, it doesn't apply. It only says that the government, if they do any action, I can't file a suit. They can't file a suit. That it has nothing to do for the recovery.
Not even for making a claim to be actionable one, my lord.
there is a procedure given to be followed by every schools. So that procedure has itself not followed now. So make no claim is actionable as of now.
I file a compilation.
Yes, yes.
We'll find.
Lord, may I request for a copy of petition because it's a paper publication, so copy has not been served.
You give a copy to.
Please. Absolutely.
It's here?
No, he is from starting.
Put on it.
Obligation.
Great.
SFP has actually become infectious. The gentleman died. The wife cannot step into the shoes of the gentleman otherwise.
I have to speak first, Mr. No. Now the question is this, Madam. If the first petition, petitioner's husband was appointed against the vacant post, but he continued for 27 years, though on the statute of interim order, which provided that, and he died in harness. Thereafter, the second 50.1, she was appointed and compassionate appointment. But even if the first case goes, but my submission with great respect to this Bharat, that the petitioner Poonam Shukla, she is a widow, she was appointed and merely because the petition was dismissed and therefore I was terminated. So kindly have one rule, they just pass on that.
I've done an NMD.
Some other treatment.
Non-machine.
She will have locus standi because her compassion appointment depends on.
She has a separate declaration pending, she shall transfer here, that it can be disposed of, because in this matter, she cannot take it.
That petition is also listed, I removed an application that has been transferred to your lordship. We have already transferred. 5 petitions pending in the High Court. And the rule itself said, Madam, like the. Lordship may kindly fix the date, some date.
They'll give the date, yes.
Lord's the contempt matter, Lord's the revision of the reservation list, despite the fact that your lordships have held 32 years back in Indira Sani, Lords, there is a specific law, Kerala law, which says that every 10 years it has to be periodically revised, Lords. Because the reservation cannot go in perpetuity, Lords. Your lordships have recently had that constitution bench judgment overruling that judgment, Lords, where they will the same judgment also. Your lordships have held that, Lords. So the idea is this, Lords, that every 10 years there has to be a revision of the reservation list. That does not happen at all, Lords. That's a thin volume, Lords, which I find, Lords, just 10 pages, Lords.
How would I want to contempt?
Then, Lords, what happens is that, Lords, I told you, I came before your Lordship under 32, Lords. I said that this directions under the judgment of your Lordships in Indira Sani is not followed, Lords. Your Lordship said you go back to High Court because it is state specific, Lords. I went back to High Court for the specific direction. High Court said, yes, on 6 months you have to comply with these directions. They came before your Lordship. Your Lordship said enhances to 1 year, Lords. Because I am basically on the compliance of your Lordship's judgment, Lords, in Indira Sani, Lords. Lordship just have this thing compiled, it only 10 pages, Lords.
Who appears for the respondent?
The state, Lords. The state of Kerala, because one is blaming the other, Lords.
I'm not blaming. Give the Union of India to 1 year's time. The order of your Lordship, which is at page 74. The special petition was dismissed prior to January
28/6/21 order.
Yes, 28/6. This was the direction that the Union of India took.
Now, let's please see the counter filed by the state, Lords. In the counter filed by the state, Lords, at page 82, Lords, the state says that they have got the particular socio-economic survey from the central government, but despite that, they don't want to do it, Lords. Because these are repercussions, Lords. You are revising a reservation list which has been existing for 75 years, Lords. Now, there is one particular caste which will be getting the entire benefit of the reservation, whereas there is inadequacy of representation with regard to the other caste members. That is exactly what your Lordships are trying to do.
Yes, but then we also held that is for the state to decide. The state has to do it on the basis of a quantifiable data.
And there is a state legislation, Lords, for that. You see that state legislation got it says.
Suggesting that since this order was passed in the Indian's matter, let them come, but that's all that I
prefer we don't erase. Like by the word AC was on in another court, right?
I've done some other.
Yes.
Who is appearing?
Mr. K.
Yep. He also appeared in that matter.
Yes, no, he appeared in that matter also. I think, if your lordship might direct the chief secretary to come online and say, as to whether they intend to implement or
Chief Secretary of
the Kerala Milords.
Mr. Gupta is very much here. Why should we?
Because chief secretary says that they cannot implement. Your lordship direction as well as in legislation.
Yeah, make it stand here. Whatever needs to be done, we are doing.
After vacation?
Second week of January.
Second week of January.
Sir, we should notice in this matter, on 2nd of December 2022, the issue is very small. Your lordships are aware that in the Godavari project, irrigation project, there are underground pipelines there, double pipeline, single pipeline. So while the work was going on, the land was not usable, therefore compensation was paid, rental compensation. After the work was completed, they filed a petition saying that no, land must be acquired and compensation must be paid to us. In the meanwhile, the government of Maharashtra came out with an act to pay compensation specifically in such cases. We followed that and gave compensation. Despite that, the High Court says it is admitted that they are cultivating the land, para 17, page 16. They are cultivating the land, they are in possession, but because the land is not buildable, they can't be used for building houses, therefore you must acquire the land and give compensation. That is the issue for consideration before lordships. And now in the meanwhile, despite your lordship's notice, they have filed a contempt petition and contempt notices have been issued against the offense.
Who is appearing? Who is respondent?
I appear for respondent, Malad.
Yes, Mr. Gandeshwar.
Malad, this is in 2010 possession was taken from us. And Malad, the act came in 2018. The High Court has held that this will not be applicable retrospectively.
No, the possession has been taken permanently or for a temporary period.
Temporary. But no, it is taken permanently because this has become unbuildable. No borewell, no construction, nothing is permissible. And this is NA land and NA potential land. This part also is considered by Honorable High Court. But would your lordship come to page number 18?
Virtually the land is drained of its any utility, Mr. Marlapale.
Yes. Kindly see para 17 of the High Court's order. High Court admits that they are cultivating the land. Admittedly, that is how the word starts. Para 17, page 16. Now they say because it has potential for building construction.
No, where is the cultivation?
Last end, they are cultivating the lands. Well, admittedly, the possession of the petitioner's lands have been taken over in 2010 for laying pipelines. The rents are being paid to the petitioners after taking the grant. It is the contention of the respondent the work of laying down underground pipe have been completed and the petitioner's landowners are cultivating their agriculture.
Contention.
They are cultivating, is a fact. Photographs.
If your lordship comes to the
potential and therefore it can't be used for building houses and therefore it must be acquired. That is the issue for consideration of your lordship. That is why notice was issued way back in 2022. Now, rather than waiting, they move contempt the officers. The issue is under pipeline is about more than 5 feet down from the surface level.
No, but then the proviso to subsection 1 that the such owner or occupier shall not, after the declaration under subsection 1 of section 4 of construct any building or any other structure.
Yes.
Or construct or excavate any tank.
Yes.
Well or resort or plant any tree on the said land, so it becomes virtually of no utility to them.
No, agricultural activities can continue, trees cannot be planted, and building construction can be. That is one of 2018 Act is dealing with specifically for this. The legislature felt the need that there must be some protection, compensation must be given to the farmers because there is some disability. Namely, trees cannot be planted or construction cannot be undertaken. It's 5 feet down the soil level, more than 8 feet.
Therefore, there is no impediment in carrying out the agricultural activity, and they are carrying out.
Make the corridor and use the land as a.
You may any time, we have no problem, but in the meanwhile, contempt notice shall.
Maintenance will be easier if that corridor is
It is not
taken.
fenced, it's not fenced.
Not fenced. Laying an underground pipeline. Then you see, what can you do on top of it?
It is completed in 2010.
Suppose you have maintenance, what will you do?
No, there is no maintenance, my lord. And even if sometimes you have to go and suppose there is a leakage, they have to attend.
Yes.
Will also be right. They will go and only, that is why there is a disability. That is why the Maharashtra is felt that it must be addressed and they must be paid compensation. Compensation has been calculated. 14 farmers have been paid compensation, ranging from 15 lakhs to 50 lakhs. Remaining said that no.
How does the electricity operate now with undergrounding of the wires?
There is irrigation.
I know, but.
They shall be.
Now, this arises out of, originally, because my writ petition was allowed, and because order of regularization was passed by the learned signatures, confirmed by the division bench, and your lordships, by dismissing the SLP, confirmed. Please note the dates. On 16th of October 2019, the LPA was 16th of October 2019.
16th of October
2019. Then Lord SLP came to be dismissed on 26th of October 2020.
1 minute.
I'm sorry.
26th
of October 2020. And then review and LPI is filed on 7th of October 2022. 7th of October 2022. So almost less than a month for 3 years. Please look at page 52 or 50. But this is their regularization. They say that the delay is of 304 days. Please see below the explanation. Though actually it is much more than 1000. Page 50, para 3. I should call that page 50.
Yes.
The applicant states that the copy of the judgment and order dated 16/10/19 was received. Thereafter, department undertook necessary procedure with respect to seeking legal opinion of the concerned assistant government bidder. Thereafter, necessary procedure was adopted by the department for seeking necessary approval and sanction for preferring special leave petition before the Honorable Apex Court. Approval from the legal department was also sought, which was received on 1/1/2020. Legal department made a communication dated 1/1/20, informed the advocate before the Supreme Court to prefer special leave petition against the judgment and order dated so to para 4. Applicant states that the department thereafter forwarded the papers in the concerned advocate of record before the Apex Court on 29/1. Subsequently, since all necessary papers were not forwarded, same were called for, and the advocate on record had called the officers from the department for meeting and deliberation. Preparation of memo of appeal took a couple of days, and the special petition diary number so and so was filed. Thereafter, with a resolution dated 23/4/2020, learned solicitor general was appointed to represent the case. The Honorable Apex Court, by judgment dated 26/10, dismissed the special petition. And here starts the lot to know. The applicant stated that on account of pandemic of COVID-19, which was rampant at the relevant time, immediate steps could not be taken at the end of the applicant's period between 26/10 to 6/6/2022. Look, COVID was much over. Your lordship started open hearing court in October 2021. Applicant stated that the Panchayat department forwarded the proposal for seeking sanction and approval with the legal department on 10/6/2020 for preferring review application. The legal department with a communication dated 23/6/2022 initially rejected the proposal forwarded by the Panchayat. Thereafter, the Panchayat department forwarded a proposal in the forms of noting before the Honorable Chief Minister state on 27/6/22 for preferring review application. Again, the judgment and order dated short. So, through the channel of submission, entire file was forwarded to the Honorable Chief Minister for seeking approval, and subsequently necessary approval was accorded to prefer review application. With a communication dated 16, it was 16/7/22, it was forwarded, informed to the Panchayat department that necessary approval is being given. Thereafter, Panchayat department again forwarded. And then, my lord, they say that the delay is only of 304 days. Here it is not written at page 7. Honorable High Court says that, my lord, 304 days delay is controlled. My lord, please see the impugned judgment of the High Court. Something which is concluded way back in October 2020, after a delay of about more than 1,000 days. My lord, that the review is maintainable after dismissal of the SLP, Puniyama, there is no difficulty about that. But, my lord, the reasons given, and, my lord, accepting it as a 304 days delay, and therefore, my lord, your lordship had issued orders. Please have a look at the impugned judgment. Lord, page 5 at the bottom. Last paragraph. As against this, learned senior advocate so and so appearing for the opponent vehemently oppose the application on the ground that here is a case in which the order passed by the division bench in retrospect and appeal is confirmed by the Honorable Apex Court, and after delayed period, the review application is sought to be filed, and maintainability of such review application is also debatable, and as such the civil application may not be entertained, since the order passed by the division bench is already confirmed. It has further been contended that here is a case in which the applicant state has not correctly stated the facts.
And the order of the High Court is already implemented.
Yes. And there are 304 days delay is stated to be.
If order is already complied with, then what grievance?
No, they want to pursue the review application. I don't want anything to hang on me. And therefore, your lordship issued notice, and the basis is 304 days delay. Delay although is more than 1,000. If they say that you will not be disturbed, you may on principle fight. I have no difficulty.
Are you willing to make a statement that the respondents would not be disturbed?
Unless I can seek instructions on that, that as far as they are concerned, if they are not disturbed, and with the rest we can proceed.
Yes, on the question of law, we will permit the review to be over.
Yes, because I tell you, Lordship, what? Your Lordship, when a similar matter has come up, it's not against this petition. Because after this, many started fighting, and I tell you, Lordships, it's important for your Lordships to know what the background is. I'm not on the financial implications, which are huge, but that alone can't be an explanation. I'll just tell you, Lordships, what are the issues in that. Now, this is my lords, your Lordship's order. In so-and-so seeks permission to withdraw these petitions with liberty to file a review. My lords have that before High Court. And in the event the petitioners do not succeed in the review, to approach the court again. Permission is granted. Special leave are accordingly disposed of as withdrawn with liberty prayed for. We further clarify that the order passed by this court dated so-and-so, which is the order in this matter, would not be construed as staying the review proceedings. Now today review proceedings are pending, and I tell you, Lordships, why are they pending? What has happened in these matters is, my lord, we have 3 judgments in our favor as far as the Gujarat High Court is concerned pertaining to contractual employees. There are 3 judgments in our favor. One judgment in Jagtiani's matter came with regard to ad hoc employees, who was a completely different form of recruitment, who after 2 years had to be regularized. It's a completely different. These contractual were only for 11 months and there was no condition provided there. Now, after the Jagtiani judgment came, the Jagtiani judgment noted that there is a difference between contractual employees and ad hoc employees.
Anyway, take instructions if you
Very well. I seek instructions as to whether, as far as they are concerned, that will not be then used against us by the others. If we make
we'll clarify that.
Yes.
We'll clarify that.
I'll come back on that. Your Lordships may have it on Friday. I'll come back.
Monday.
On Monday.
Please.
I'm appearing for respondent number 6, original petitioner, madam. I had filed one item, but we were not served at that time, that is IA 137-355. I want to withdraw that. Because I have already placed my counter affidavit on record, but we are similarly situated.
Allowed to withdraw.
So, Upadhyay is Mr.
Yes.
Yes,
Since then, the
same point.
Since then, the rules. Since then, my lords, the rules were amended. After that, ordered and took the exam and have been regularized by taking an exam. So that stage is over now. The problem here was there were two completely different categories with 3 judgments in our favor and one pertaining to ad hoc employees, which is a separate category. A 4th repetition is filed by them after losing in 3, and that 4th repetition, that one judgment of ad hoc employees is simply following contractual matters without any application. Then the facts are completely different.
Take this.
Well,
May I request one thing? Instead of Monday, we have 7 on reopen. Allow some difficulty next week.
Entire week. Friday.
Friday. Friday. Grateful. Very.
Minutes, with my lordship's kind leave minutes, I appear online.
In this matter,
We'll have it on NMD.
Minutes, may I just submit 1 minute without obstructing your lordship's proceedings? Minutes, it's an order based on consent, and they're still dragging us.
Lordship.
and then they were near the minutes, it may be.
Kindly see at page 9.
Mr. Sejadri, we have issued notice.
Minutes, my lordship, kindly have a look at page 9 minutes. Where they've consent.
After notice, we have to hear them. And there must be some reason as to why we have issued notice.
So be it, minutes. Any early date minutes, we've been suffering, which were in industry, we have no electricity connection, we have paid the entire amount under protest. Kindly have an early date minute. That's all my prayer is.
Immediately after.
Grateful minutes, deeply appreciated.
I'll just take a few minutes. Kindly turn to the lordship's order of 17th May 2024. Paragraph number 8. Your lordships had said that we do not wish to observe anything with regard to the order dated 17.
I submitted the calculations, how much is taken.
I'm telling you.
He's taken 3 promotions, and where the people closest to him have not been promoted, we disclosed it on it.
I'm not on the question of promotion.
The entire amount which he's claiming, we have reasons he was AWL, we stated we've given 36 lakhs according to us. Now he's claiming around 5.5 crores.
More than that.
Well, this is like straight out of
NMD.
May I just request your lordship, Milord?
NMD after vacation.
Milord, kindly give me a date, Milord, at least.
We'll give you a date.
Milord, can it be next week, Milord? He's really hard pressed for money, Milord.
Immediately after vacation.
Can I get that?
So whatever you, according to you, he is entitled, you pay that off to him.
Milord, my entitlement is 1 crore and 70 lakhs.
Okay.
So, Milord, may I just request your lordship to kindly give me a short date, Milord. Fixed date, Milord, in the month.
They will give the date you are told.
In the month of January.
Only 13 was possible.
Item?
13 was passed over.
13.
Only one IA is listed today.
But then the repercussions, I find difficult to convince myself some logic in the petition. In fact, to challenge the provisional act, you'll also issue a mandamus to the government. Parliament should amend the law and things like that.
Let the petition be listed along with this.
So, my application, there are 2 applications.
I submitted was called that one application is already dismissed by virtue of the 7th of January 2021. What remains only an application whereby we seek certification of the AR.
259758.
That's correct. 25975.
They want a court intervention.
Have some difficulty now. This kind of substitution, how does it really happen?
This was a petitioner. How can we grant such a relief?
For substitution of AR?
No. In the main relief in the petition.
The petition is not in a listed way. We are only this to
List of application along with the main petition.
Right.
And item 56, why issue notice, my lord said, granted status on the property. They started construction, my lord. I filed a contempt petition. On the last date, they requested for some time to file counter affidavit in the main. Till it is not filed. My lord may issue a formal notice in the contempt petition.
I'm sure not by counter. There was a change in counsel. That's the reason that the counter is ready filed during the course of the date to dates.
Yes.
I brought it to the court.
Ravindra Kumar, the learned says that the counter will be filed during the course of the day. Put it after it.
It is a short matter.
No, I'll seek a short passover in the matter. We have been head by Ms. Meenakshi Arora, senior advocate. She's on her legs before court 3.
We'll have it in the next
Because they have it for
next week.
next week.
Lord, may I only make one request then? Would your lordships stay the elections in one court alone, Rose Avenue court alone? Because what is happening there?
Not may
Lord,
have it
I was
in that case next.
till the next hearing alone, more than not because the bar council.
Is the election notified in the week?
No, not notified, but the process is going on.
Okay, we'll consider it in the next week.
Not any day. Look, I should not take more than 10 minutes for this. My point's very short. Your lordship could have it also subject to.
We have filed a Wakalatnama for Bar Council of India also, Your Lordship.
But the arguments are going to be very
And
strong.
that affidavit
Legal. Nothing more, I find my summary also.
Okay, so we'll have it in the next week. Yes.
Yes.
Great to know.
For respondent 2, 3 and 5. For 3 and 5, I have filed my Wakalatnama on Saturday, my name start, and for 2, Miller instruction to appear.
When do you want?
I have it after vacation.
After vacation at the request of the consul.
So great. But my parents will be taken because my Wakalatnama.
They are not physically.
What happened? Joined?
We haven't received any communication from respondent, but we go to email as well. Send it a control answer. That's it. Haven't seen it.
What happened? Seat was to be given as per the last order.
They're already directed the respondent to who is applying for respondent to? Take instructions, we'll have it tomorrow. Or day after tomorrow. Take instructions as to whether our order has been complied with or not.
In Lordship, I think respondent number 2 would be any law for Union of India paying would be a peer for NCC.
Who is applying for Union of India?
Union
NCC, I think Mr. Gaurav Sharma appears.
Mr. Kaushan does not appear for Union.
You are appearing for whom?
Served through learned ASG of Lordship for Union.
Which learned ASG? No copy to Mr. Banerjee. We'll have it day after tomorrow. Inform him that we'll have it day after tomorrow.
That's my humble apologies for so.
Take your breaks.
I'm an accused in 2 crimes. In both crimes, I've taken a plea. I'm not a public servant.
Wait for it. Catch your breath, Mr. Naidu.
Yes.
Point is very short here.
Yes, indeed. All that I raise that the observations in third parties petition should not affect me. My trial prospects will be seen because proceedings are pending.
The petition is that the observations of the High Court in the impugned order would prejudicially affect the rights of the petitioner in the proceedings against him. We clarify that in the proceedings against the petitioner, the observations, we clarify that the observations made by the High Court in the impugned order would not adversely affect the petitioner's proceedings.
Grateful.
This we got to pass on the first occasion, on the second occasion also, but for some obvious reasons we did not.
We did not do it.
I'm sorry, I beg your lordship's pardon. Once in a blue moon it happens, because getting
No, you don't get the word obvious reason within inverted commas.
I'm grateful. There's a delay needs to be corrected.
There's a 673-day delay in filing the assembly.
But what remains?
The lawyer passed away. But what remains is the observation that there are 150 members and they have to be considered.
Or over 2019.
Well, subsequent elections have happened, we are in control. What happens is this is causing, they are filing suits against us and.
Restore. MA allowed restore. This will be taken on file. We are not intending to interfere with the impugned orders. However, the question of law is kept open.
My lord, liberty to file review petition. Charge sheet is filed.
After so many years, review now.
No, my lord, now what has happened is, pursuant that list is a forged list. In that list, charge sheet is.
Say that liberty to withdraw with liberty to take such steps.
Well, one will be to file a review petition, my lord. Otherwise, this observation is coming in the way that 150 members will have a right to agitate.
Allowed to withdraw with liberty to take such steps as are permissible in law.
Mention with my lord's permission, I don't agree.
बैठेगी तो दीपक जी, दीपक जी, दीपक जी, 2 मिनट बैठेगी।
And please, your worship.
It's not complete.
Before I refer to it, let me broadly tell your lordships what the issue is. As your lordship knows, Manoj, now we have state backward commissions.
How much is your estimation?
Okay. Appeal is, should be, this is the list of rates for an indebted, with hardly a. I am not making it out in part of it. Commission, but the High Court from, I'm just observing that some expense. What must decide whether they are in, otherwise.
Okay, there are about
State of
difficulties for both of us. We have some meetings. It doesn't get over by 3 o'clock, then.
Can't finish it. That's
Committee meeting. Committee for me.
I have something to.
the High Court, process of gets up. So I'm just why better silence is better hearing then I start. Your lordship may set the main appeal for hearing in January. Your lordship can set down the main appeal itself in January.
For hearing, how much time you are likely to take?
Well, that's it, 1 day total. Yeah, 2 afternoon
What?
sessions. 2 afternoon sessions.
Oh.
1 afternoon for them and 1 for us. Your lordship may ration it. Yes, sir. We have circulated a note, but it won't take very long. Your lordship may give them 1 afternoon and give us 1 afternoon, and rest we can give in writing. Your lordship had fixed it up only for the interim today.
Today, so therefore then we will fix it for final hearing on some.
Correct, but what happens is that in the meantime, people can't get admission to universities, but they can't get employment because the reservation is in there. Nothing is going to happen, my lord. It's the earlier instructions are in force and the reservation of early is in force. Only additional reservation will not be there.
Reservations were made in 2010 and 2003 and have been operating over till the judgment.
The judgment, yeah.
Next question.
12 lakh certificates have been cancelled.
One more thing, Manoj. Unmindful of the High Court order, there have been subsequent recruitment processes where they are going back with the same list has been watched. They are coming here and saying they are having difficulty.
We have not filed any contempt. Your lordship may post it in January, 2 afternoon sessions. It will finish.
Since 2010. So only one of the back.
Retired judges का कब रखा हुआ? Retired judges का?
And there are names in the central list. If they have to be retained, you can't point to under the central list. Then you have a reflection that that central list is based on the state list.
That's not what I was saying. Central list is earlier, what I was saying.
But would you like to have this side of the vacation or the?
Yes, sir. Yes, sir. Let it be that side. No heavens are going to fall. Not. It has been pending. We are not saying heavens are going to fall, but lives are at stake. Practical, your lordship will have also time. No heavens will fall if it is stayed also. It's been going on since 2010.
Time we can have this side of the vacation also. If you, in any case, if you have to fix a day.
Yes, having this side of the vacation maybe miscellaneous. That doesn't matter. We can sit in the afternoon. Let it all. Let it stay.
You cannot debate on this side. But realistically, this pending since last.
Yes.
Quite a few.
Yes. That is why now that your lordships have heard, hearing it, otherwise it was coming up on the list remaining. We have mentioned about 10 months. Let it come up in January.
No, that is not fair because Mr. Sipal mentioned it.
No, that is right.
7, 8 or 9, 9, whatever is.
What happened? 8 or 9? What? This time it's possible only now. It's all right. You're going to be here, no, in that one?
No, because you are quite apprehensive about your estimates. Though you say that.
I say we'll all finish in 2 hours. It's our commitment, Your Lordship. Yes, it's our commitment. We'll not worry about
That I've been hearing for last 5.5 years.
I make this commitment on behalf of my side. We'll finish it in 2 hours.
Everybody begins his argument with this sentence.
No, but I'm sorry to say, when I've given a time.
This is not even a matter which can be like that.
I was in making it that we give a commitment that we'll finish it.
Very important.
No, we are.
Here elaborately, because otherwise we will have to grapple with it.
That is a Tuesday, 7 January. And so that if we keep it this side of the vacation, then we don't know whether we will be in a position to extend it to the next day or not. But at least if it is in the January, if it doesn't get over on one day, we can have some time.
In the morning then, Manoj.
Why, from the morning, yes.
Then it's be over, Manoj. That's fine, Manoj. That's item 1, Manoj.
Item 1, yes.
Item 1, that's fine.
In the meantime, can you just
Yes, given.
in 5-10 minutes, just give an overview.
I'll give you a losses. I'll give you a losses that overview. But as the state of West Bengal.
Yes.
Manoj, as your lordship now knows, Manoj, that several states have their own backward responsibility. The state of West Bengal, Manoj, has a minority population of about 28%, out of which more than 27% are Muslims. The Ranganath Commission, Manoj, in its recommendations, recommended that 10% reservation should be there for Muslims. Manoj, as far as the Hindu communities are concerned, Manoj, there were 66 communities that were classified as backward, as far as the Hindu communities are concerned. Now the question arose, and that's the majority, Manoj. The question arose, Manoj, as to what is to be done to pay the reservation for Muslims. So the Backward Commission took upon itself that task and identified 76 communities to be classified as backward. 76 of them. And Manoj, most of them, a large majority of them, are included in the central list. Before Manoj, this classification. That also has been struck down. Between 2010 to 2012, Manoj, and this has been going on since till Manoj, this judgment came in 2023. 24 it came, Manoj. So 44 of them are within the central list. Then a certain number of them are also part of the Mandal Commission, which are recognized, Manoj, by the Mandal Commission. And then the balance, Manoj, are part of Hindu counterparts and in SC/ST and OBC Hindu counterparts, and then the last category in the neighboring states. So this makes up of 76. This exercise was done by the Commission pursuant to the hearings made. And the Commission Manoj recognized these 76. But unfortunately, Manoj, the High Court has struck it down, heavily relying upon the Andhra judgment, your lordships will remember, where the 4% reservation was there for Muslims. That judgment has been stayed by this court. That judgment has been stayed by this court, and that matter is pending before this court. Whether or not Muslims are entitled to classification or not has been stayed, and that reservation is continuing in Andhra Pradesh. And the High Court here relies heavily on that judgment. So that's my lord is just getting on overall broad. So that's the issue. Now, when the state of West Bengal, the West Bengal Commission decided on these backward communities within the Muslim community, then the issue of sub-classification came. And we decided to do an exercise. Now, as far as the inclusion within the backward classes is concerned, that was done by the Commission. When it came to sub-classification, that exercise was delegated to the Calcutta University. And there's a CII, Department of Anthropology. CII did that exercise. And that recommendation was sent to the Commission.
sent to the government, and the government recognized the other backward classes within the backward communities. And there were 143 of them.
Other backward classes within the backward community?
Within, like the constitution and judgment,
Sub-classification. Sub-classification amongst the scheduled castes.
That's correct. So that exercise, your lordship, has now been upheld in the constitution bench judgment. That also has been struck down. Not only that, but the act itself has been struck down. That the government does not have the power to do this. So there are highly contentious issues involved. And part of the argument of the other side is that the exercise that was sought to be done was not done properly. AMAL Chandra's will demonstrate to your lordship that everything was done properly. In fact, we have set out in this note the meetings that were held, the public hearings that were held, the number of times that we went to those particular areas where the backward community resides, and all that was done by the commission itself. When it came to sub-classification, that your lordship knows the government is entitled to do that. That's not a task of the commission, but that was delegated to the CRI.
That also can't be done unless there is a quantifiable data.
That's right. That is there. That is there. All that is there, Manoj. That quantifiable data is there, Manoj, and the identity of the sub-classified categories are also here. So that also was struck down. But Manoj, what is important is that the act, the provisions of the act itself were struck down, that you can't delegate this. So these are very serious issues involved. It affects the lives of thousands of students, mothers, who are aspiring to be admitted to universities, people who are wanting jobs, mothers, and therefore it's not. And if in principle Muslims cannot get reservations, that's another issue. But if they are entitled to reservations, then this question arises as to how this is to be done. And according to us, mothers, this was all done.
No, reservation can't be on the basis of religion.
That's what the argument is, mothers, which has been stated by this court in the Andhra matter. It's not its backwardness. It's not. Let's go on.
It's a very utopian kind of argument which my learning friend is making.
If you don't mind,
what the court finds.
That's right.
We'll also hear
this is a unique way of arguing nowadays in this court, mothers. Mothers, we are not.
And with this, is it possible to stick up to the 2 hours you are?
I will stick up. I mean, I sort of I admire the patience of the other side, and they will let us argue for 2 hours without interruption, and we'll appreciate that. So we will certainly finish in 2 hours. The question is, this is not on the basis of religion. This is on the basis of backwardness, mothers. Not on the basis of religion, which your lordships have upheld. Even amongst the Hindus, it's the basis of backwardness. Backwardness is it's common to all sections of society, no matter which religion they belong to. It's also true of Christians. So, that itself, on the ground of religion, is not the issue here. It happens that they belong to a religious community, but they are backward. And that's the question that your lordships will have to decide. And then broadly, these are the issues. These are the broad issues that your lordships will have to decide. And the impugned order itself at page 209, it's very interesting. Kindly have a look at it. Page 209. I just read it. You're also need to open it. See the directions. The court says, it said direction. The opinion and advice of the commission is ordinarily binding on the legislature under sections 9 and 11 of the Act, irrespective whether. Sorry.
Yes.
At the bottom of page 209. Yeah. The opinion and advice of the commission is ordinarily binding on the state legislature under sections 9 and 11 of the Act of 1960, irrespective whether a request to look into over-inclusion or under-inclusion is made by citizens or body of state. The expression government of West Bengal and government in section 2F of the Act is then down to mean state of West Bengal in discharge of its legislative functions, having due regard to the reports of the Commission under the Act. Now, the next is important. The second part of section 2H of the Act, which reads, and I quote, and includes such classes as the state government may by notification of the official gazette specify from time to time is struck down. Because how could such an act, such a provision be struck down? That the state has no power. But the recommendation
this will be contrary to Chinaya.
Exactly. It just cannot be struck down. They've struck it down.
You said because the commission did not do it.
Commission did it, Commission did it.
So you said it was given to the university.
No, that's for sub-classification.
That's what is
the inclusion is done by the commission.
Inclusion is done by the commission. Include such classes. The inclusion is done by the commission.
I say the provision of the act is.
Yes. Kindly see the act says, Malak, this is very strange. It says 517 volume 2. Lists means list prepared by the government of West Bengal from time to time. And H is other backward classes shall mean such classes of citizens as specified in Schedule 1 other than Scheduled Class and Scheduled Tribes and include such classes as the state government may by notification of the official gazette specified from time to time. Struck down. Commission recommends and be notified. Mother, how can this be struck down?
The power is executive.
Yes.
We have not differed with the commission, brother. Whatever the commission has told us for inclusion, it's the act itself is struck down. The section itself is struck down. So brother, this is completely wrong. Now, can you see the next? It says section 16 T is struck down since it empowers the state executive to amend any schedule of the Act of 2012, including Schedule 1. Consequently, the 37 classes included in the exercise under 16 are struck down from Schedule 1 of the Act. And C. 16 says the state government may by order published in the Gazette add to or amend or alter any schedule. That itself is struck down. If we do something at the instance of the commission and we alter it, it's struck down. The power is struck down. It's against the constitutional judgment. Schedules can be amended, power is with the government and the legislature has given that power. So that now see 5A. 5A of the Act, one second, let me read. Of 2012, which distributes the percentage of reservation in 10% and 7% to the sub-classified classes is struck down. Consequently, the sub-classified classes listed in the two categories, namely OBC A, OBC B, are struck down from the schedule. So the sub-classification is struck down. And what does 5A say? Subject to the other provisions of the Act, 10% of the vacancies shall be reserved for candidates belonging to other backward classes, donated as other backward classes category A. Category and 7% of the vacancies shall be reserved for candidates belonging to the other backward classes category B. Category of the other backward classes in this is structure. So I can't have a classification of other backward classes, which is contrary to the constitutional judgment. Which is why we said that this has been continuing since 2010, 2012, struck down in 2024. Benefits have been given to us over the years. And then there was over the page at 211G, the executive orders dated so and so, issued by the government of West Bengal, backward classes welfare department, subclassified 143 classes are struck down. And then the executive orders classifies, no, this is important. The H is most important. The executive orders classifying 66 classes prior to 2010 are not interfered with since the same have not been challenged. These are the Hindu bullets classification of backward classes of Hindus. 66 bullets of them, they say we can't strike it down because nobody has challenged it. The same process is followed prior to, the process followed afterwards, is struck down. Process followed prior to, the same process is not struck down because it's not been challenged. I mean, this is bizarre. Therefore, constitutionally, ex facie, this High Court order has to be stayed with the greatest respect. And then 200, para 2,
Para 2 at?
Because it's not challenged. This, they say the process is bad, so we strike down. So inclusion struck down, sub-classification.
Class J. Clause J.
Clause J, backward classes, welfare department of the state in the exercise of power under 11 shall in consultation with the commission place a report before the legislature with recommendations for inclusion of new classes or for exclusion of remaining requirements. Where's the question of legislature coming in here? This exercise has to be done, If the legislature were to do it, you will strike it down saying it hasn't gone to the backward class commission. If the backward class commission does it, Madam, you say it should be done by the legislature. And your lordships have deprecated the practice of the legislature deciding this because they have their own political considerations. So, Madam, with the greatest respect, it is my humble submission, Madam, since
No, clause K doesn't make any.
Yes, the services of citizens from the 77 classes and 37 classes added in the exercise of section 16 struck down, who are already in the service of the state or have already availed the benefit of reservation of succeeded, shall not be affected by the reason of his judgment. That's this year onwards, brothers. We can't do anything. No reservation at all, brothers, in admissions, no reservation in employment, no reservation in promotion, no reservation in scholarship. So what kind of orders are these? I said promotion orders. So, brothers, with the greatest respect, it's fine, your lordship may list it anywhere, but some interim order has to be passed, brothers, to help us.
We'll hear it.
Yes.
We're saying that we'll hear it.
Yes. Your lordship wanted a bird's eye view, brothers, I give it to your
Now,
lordship.
we must hear Mr. Patwali.
Yes, yes. There are so many solicitors. But if we have any, what? Yes,
Yes, in any case, we are not hearing it today, so unless if you want to say something.
What on behalf of petition, if I may have just 2 minutes. One of the reasons not given is that the Muslim counterparts, these, that a barber who is Hindu is included, OBC. But a barber who is a Muslim, if he is not to be included, that is said to be based on religion. And just look at this, I'll just read 2 paragraphs. He says that High Court says at page 174, there is a set of classes who once belonged to the Hindu religion. Page 174.
Yes.
L. HI. There is set of classes who once belonged to the Hindu religion and are stated to have been converted to Islam. The Commission does not, however, advert to the question of why such classes converted. As to when and whether such conversion was done for getting a reservation for the state services. Here by conversion they are losing. Where is the question of converting? Has not been considered. Most importantly, some of the said classes were enjoying reservation as scheduled castes when they were Hindus. The question therefore that would arise is why a class which is already under the reservation scheme would convert to the Muslim religion and will get a reservation based on the ground of the class having previously. So the perverse reasoning.
But there are therefore serious doubt on the bona fides of the service.
So what is the doubt plot in this? What we have said is that a Bhangi Hindu is already reserved and getting reservation as a scheduled caste. Untouchables.
Why should you convert to Muslim?
Why you have converted to Muslim? So because of conversion, now he can't be included in the scheduled caste because he is not notified. But he is backward. He has been included as a backward class, not as a scheduled caste. So person who is Dalit doesn't cease to be a Dalit on the face of it, ex-specie.
No, but in so far as ST is concerned, if he is not from those religions which are listed in the presidential order.
So they have not been included in SC/ST. They have been included as backward class.
Because scheduled caste would be only restricted to Hindus.
Now, the lordship 5 judges in Journal 6 says scheduled castes are backward class. I can't include them in SC because President has not included them in the list. That's correct. They have therefore not been included in the SC list. But for that reason, there is no prescription under the constitution that they can't be included as a backward class under 16(4).
Learned judge relies on journalism.
Yes. Yes. And just look at this, the bold portion at the bottom goes against the print of the judgment. The test for requirement of social and experience cannot be applied to the scheduled caste. They are deemed to be. So at least they are backward class. If not in the category because of non-notification. Now the second thing is this, Lord.
If all these counterpart Hindus are already included in the backward class or scheduled caste list, if you do not include the counterparts, then that is exclusion based on religion. This is not a case of inclusion based on religion, but it is a case of rectifying and correcting, my lord, the wrong, my lord, because these Muslims who are counterparts were excluded. So therefore, this is an exercise by which, my lord, this exclusion based on religion has been undone.
Yes, Mr. Patwari. We just wanted to have an overview. We will be hearing everyone. Yes.
Can be found forgery. Now this part has by the High Court on the where the High Court takes.
What Indra Sari says that the Muslim community can be considered as.
It's found to be forgery.
Then it is a class and not a caste.
Now that is misinterpreted. That precisely was the error, Maulana. I'll give it to him.
In West Bengal, quite clear from 1882 census that the majority of OBCs in West Bengal are in fact Muslims. Because that historical context has been completely missed by the High Court. Now, if majority of OBCs are Muslims, of course, most of them will properly examine the Muslim community. The High Court has been over-impressed by the fact that how can there be so many Muslim class without examining the fact versions which happened 200 or 300 years back were mostly of Muslims into the OBC. That's one aspect.
Conversion of Muslims into OBC or conversion of Hindus into Muslim community? Hindu Muslim. Okay.
That aspect is not, I mean, at all.
Yes, Mr. Patwari.
Now, the point is, the High Court finds, and my friend has argued, this survey was conducted, that data was there, this happened. High Court finds there is no survey, there is virtually no survey, there is no data, the commission has been bypassed. What actually happens, a statement is made on 8th February 2010 by Honorable the Chief Minister of the State. Prior to that statement, from 94 to 2009, there are total 66 classes declared as backward classes. On the date the statement is made, within 3 months, 42 classes are declared backward classes for inclusion. 41 are Muslims and the rest are otherwise. Within the next year, 56 more OBCs are declared. So, just close on the heels of the statement, over 108 classes are declared backward classes. The High Court, we move applications under RTI saying, what is the survey? Where is the quantifiable data? Indra Sani and subsequent judgment says, you cannot do it unless you reach it, accord a finding of backwardness. It comes out, there is no survey, there is no data, and therefore the order was passed by your lordships on the very first day when they wanted an interim order. Please show us what survey was conducted and what data was there. High Court has examined it at a number of places. For illustration, see page 150, para 266. Please see this. This is all, the commission is bypassed completely. When they make classification, it is their pleaded case, we have bypassed the commission. The High Court finds serious flaw with that also. I'll show that. Just see page 150, para 266. The heading is the haste. What's about that? What about it?
Page?
Page 150, para 266. And therefore the High Court says you can do it, but please conduct a proper exercise and do it. And reach a proper conclusion. Now see para 266.
No, the High Court says that the backward classes, the Social Welfare Department of the State Bengal, in consultation with the commission, shall prepare a classification and place it before the legislature.
Yeah, that's the act. We will show the act also, but just see the
Basically what, where the High Court has held against them.
How
No
can,
quantifiable data.
how can a provision of a statute be
But
held to
Enabling provision.
there it was.
on the
They
contrary,
amended it.
on the contrary, right from Indira Sani, it is held that it is the power of the executive
Yes, but
to classify and identify.
they diluted it. The provision first.
No, but an act of identification, classification, one can understand could be, but how can on that ground the provision in the statute be set aside to enable the state to?
It was diluted to make the commission's consultation not mandatory, but ordinary.
Misuse of a provision, can it be ground for setting it aside?
But basically what the High Court says is inclusion of these castes is bad. Please have a
Then you should not have struck down the enabling provision.
But enabling, because the High Court finds on account of that enabling provision, which says ordinarily consulted, the commission is being bypassed. And if your lordship wants to see, I will just show that now first. Please have page 87. Please have page 87. It is not, in fact, the judgment is a sequitur to what went before the High Court. Please have page 87, clause E, the heading. The state could not have bypassed the commission, even while sub-classifying the classes. The court finds.
We can understand the court holding that the sub-classification is bad.
Correct.
On account of non-consultation with the commission. But on that ground, how can it set aside the provision which enables the state government to classify and identify?
High Court, it is still the powers of the state government,
No.
but without bypass. Just kindly see page 87 with me for a minute. Page 87.
Read 210 clause C.
Clause C. The second part of 2F, which reads and includes classes as the state government may by notification in the official gazette. State government cannot do it. This direct power, of course, ultimate notification may be by the state government, but the state government.
Yeah, how can you grant them such a power?
What the High Court finds, the state government is merely issuing a notification. Your lordship can consider this direction. What the High Court wants to say is that the state government, without quantifying.
What the High Court wants to say can't be what Mr. Patwalia says. It has to be read from the judgment or as it is.
Once your lordship sees the judgment, your lordship.
Unless you have some power to read the mind of the learned judges.
To come to this, please read 2 or 3 pages with me. Please see page 87. Page 87 first. Para 111. I will read everything which I want to read. Page 87.
Yes.
Yes. Now kindly see para 111. The state could not have bypassed the commission even while sub-classifying the classes. On a query from the bench as to why the state did not consult the commission while sub-classifying the classes, or why it did not at least forward the report of the anthropology department of the University of Calcutta to the commission for its consideration and advice, the learned advocate general said, possibly the state wanted to have benefit of a much higher expert body than the commission. In this regard, the court notices. So everything is being done by notifying everything, but the commission is being bypassed. So therefore, the High Court steps in and rightly so. In this regard, the court notices composition of the commission as indicated by section 3 set out as hereunder. Then para 113. The commission comprises a social scientist, 2%. Then it goes into the details of what the commission comprises of. It goes into various judgments. And then ultimately, your lordship may come to page 101. The conclusion is at para 141. After noticing all judgments on this at 141, please have the conclusion. Repeatedly, the court finds the government has been bypassing commission. Just see now para 141. In the facts of the present case, your lordship, in the facts of the present case, the petitioners have successfully shown, and the court has found that the state did not consult the commission while making some classification of the classes. The petitioners have also demonstrated that classification of the classes by the state is not supported by any cogent and scientific report or recommendation of the commission. The court in the course of hearing has noticed that section 9 has been amended by the state for diluting and to some extent negating the advice of the commission. That's the reason. Therefore,
how can that be reason for setting aside the?
So, Your lordship can by a judicial order say that this is mandatory procedure, the purpose of the amendment. Now, see the prior and later. Prior says this cannot be done without consulting the commission. Advice of the commission shall be binding. Now,
This is under the concurrent list statute, is it?
Correct, correct. And then they amended by saying ordinarily binding, by introducing the word ordinarily.
What did it have, presidential assent?
That's not coming out of the judgment, what I can check out. But please read a little further with me. Your lordship will see what has been happening. It appears at this stage that the state has been making an invidious attempt.
How would it come in concurrent list?
No, it's not.
List 2 then?
Yes.
No,
It would be.
the original statute, the Backward Classes Commission Act,
93.
that's a,
So every state has.
every state has a.
Every state.
There is a background to the settings that they are arguing. They have taken out literally one portion from the include order and read it to my laws. It will appear that the whole thing is illegal. No. There is an entire reasoning with the High Court for this. There is a 1993 State Act for us. That State Act in terms.
Yes, please.
State 2 minutes.
Yeah, my friend had argued that.
Look, sir, 93 Act was made by all states based on Indira Sani. Indira Sani said state has the power for 16, 15 to make provision for reservation for backward classes. But then twin tests have to be satisfied. Backwardness, and so far as 16 is concerned, inadequacy of representation. Indira Sani, paragraph after paragraph, opinion says you must have a backward classes commission of experts to advise the state. Based on that, all states have made legislation. State of West Bengal also made this law in 1993. What they do was, they are supposed to have taken an opinion on the Backward Classes Commission in 2010 to add 42 communities in the first branch and thereafter 35 in the second branch within a few months. That itself takes place after a specific political statement is made by the Chief Minister saying that a particular community today is going to be provided reservation. This fact is a very, very important fact. Admitted by the state and the Backward Classes Commission forms one of the most important grounds for the judgment itself. That's noted in paragraph after paragraph. Now, that exercise provides result in that this being made of 42 plus 25. What the state does in 2012 is make an independent law for the purpose of 16.
Correct.
In that law, the state makes the definition what is read out by Mr. Simal, where the second part of the definition gives them the parallel power without referring to the commission to make reservations. That part of it, High Court says you made a law. And Indira Sani requires that you must consult the commission. Can there be an independent power, if unchannelized power to the state, for it to make reservations independent of the commission? That part alone is therefore set aside. That is one law. That's the most important part. In fact, there are a number of pages reserved in the include order of that. Just note the heading alone, bro. In the include order, they have given the argument to great detail in the High Court. That's why I place in all this words. You see. The include order index. There is a separate discussion on this point. That my lords may know. Point number H.
Okay, we'll hear it now.
That's second point. They are arguments saying that no reservation, the state completely wrong. They are placed in the same position as what they were in 2010 prior to these inclusions. That's the second thing. It's a different levels. The High Court has found in some cases, perhaps, there's an application in a printed format which is given by one community. They say the hearing takes place on the same day. No one-way survey, nothing at all.
No survey at all. That I would have come to that. But just
Someone itself is at different levels.
Just see para 143. It appears at this state has been making an invidious attempt to negate and ignore the advice of the commission. Very strong words for
advice.
And secondly, my lord, the court therefore says in our please. So this is Mr. Sibbal just made some kind of parallel. Now, my lord, kindly see page 146. This court needs to examine by judicial review whether polycentric examine.
Reserve your energies for 7 days.
Just ask them, what is their locus? How are they here? Before the High Court, how are they in the High Court? They are not, this is some public interest litigation. PIL, this is truly PIL, P in inverted commas.
You want to take away our jobs and then say it's a
PIL.
contrary to rules of the Act. Take away our jobs.
And the commission has been consulted throughout.
We have annexed the survey report.
We annexed the survey reports.
There's much to be said about those survey reports.
That's fine.
Your friend is saying there's no survey.
Can file an appeal. What's their location and Mr. Sim?
Yes. That's important.
We thought we were
There
responding.
are comments made on the commission. That's right, that's why they're fighting. Anyway, let's not get into this. Seven.
We'll hear.
I can one to seven. Keep your best.